Pardon to mention, Lordship, after notice matter, my lord, it was fixed to 12th of
all fresh admissions give it. Question on Monday, Tuesday. All fresh admissions.
after notice matter.
April salary matter of 2019. April salary matter 2019.
Take it week after next.
Pension matter 2024. Not getting even provisional pension.
Recovery matter is great for employees retired, but recovery unilaterally without giving her chance to manifest.
Which year, man?
In 2023 recovery.
23. All 23 matters 2 weeks. 24 matters 3 weeks.
23, my lord.
5 matters 4 weeks.
23, my lord.
23.
24 Lordship.
Pardon to
Next time in the set the norm now.
Year of 2018 matter, my lord. Appellant is often stay order.
Next.
Wanted
Pardon to mention, my lord, family pension matter. Family pension matter urgency is
Which year?
24.
24. All 2 weeks.
So, Lordship, pardon to mention, only the matter voluntary return from service and matter 24 matter.
24.
24.
2 weeks.
Pardon to mention, Your Lordship, this is 24 matter.
You have said, give that.
Yes, my lord, pension matter, my lord, 24.
Pardon to mention a specific adjournment 17 February. Your Lordship, 24 matter.
Which, 1 second. Call the base one.
My lord, matter of 2020 for the petitioner is a minor student of 12th class. He has awarded. She has challenged the award of 0 marks against some answers correctly answered by her. It is a matter of 24. But however, the petitioner has this minor student has also taken a 1 year probation.
Item 1 and 2, can you add them to next week?
Items 1 and 2. 23 matter.
My lord.
All right, 1 and 2. All week after next, the request of.
My lord, item 13, 15.
Next date, no adjournment. Next date, no adjournment. The request for adjournment shall be entertained. Yes, 23 matter. People will be laughing at us.
13 and 15, my lord. Next week, 13 and 15.
15. Which year? Here you have to tell, no?
25, my lord.
25, all right. 13 and 15, 3 weeks. That's a request of.
Well, in this case, I appeal the opposite party, the state. Lords, I have to Monday, Lords.
Next week.
So, my lord, item 25.
That's the request of.
Item 25.
25.
There's 2025. Yeah. I adjourn next week.
First week of August. That's the request. Yes.
Item number?
Page 4. 31.
Only gentle lady. There is only one gentle lady. Ask them. Which
Item number 64, my lord. I pray for 2 weeks after Mr. Rudra Prasad Kaur, senior advocate, is appearing. He has some personal difficulties, my
2
lord.
weeks.
64, my lord.
2 weeks at the request of.
Item 1. Item 1.
1, 2, 4, 3.
Item 3, my lord. Today, I am filing one affidavit indicating the present status of that pension matter, your lordship, other day.
Pension.
Yes.
Papers are to be signed, this, that, etc.
Yes. And some amount is outstanding here.
2 lakh rupees was due, wanted to recover.
Your lordship, affidavit, and I have sought the copy to my land.
When have you served the copy?
Yes, always so.
When have you served the copy? Who appears for the petitioner?
I sought the copy.
You have served on him?
Yes.
We'll call this matter after 2 weeks so that he will read and come back.
Yes, sir.
Call this matter after 2 weeks to enable counsel for the petitioner to come and argue.
Last occasion, Your Lordship directed to Accountant General to submit the present.
Yes, come.
Yes, come.
Yes.
Petitioner also. Recall that. Have you seen the objection statement?
Affidavit they have filed, and your lordship, last occasion, lordship, they said that they have already sent the papers to the AGO.
No.
But it is not a fact. My learned friend is appearing for AG. Your lordship remembers that.
I remember.
Yes.
You said that.
Yes.
You can't say no. Otherwise, I have to replay the video before you will be insulted.
No, you're maybe. Other day, your lordship, I remember, I have said that some amount is outstanding.
That you say 2 lakh rupees plus is outstanding. I
Yes,
remember
yes.
that also.
Yes, ma'am.
I
the-
forget that thing
the
so
pension-
easily.
The deponent has already submitted the pension paper and it is pending before the sanctioning authority.
Who is the sanctioning?
That is director technical team.
Why you are not keeping that matter pending?
Pending because your lordship may kindly see my affidavit at page paragraph 6.
Paragraph 6.
Yes.
Pertinent to mention.
Pertinent mentions that during verification of pension papers of the petitioner, it is ascertained by the
Some
department.
amount is pending due with the petitioner. How, in what connection it is pending?
He was given advance and he has not submitted the utilization certificate and that is it.
And that is of the year 1995, 96. 96, 97. Now they are saying for the first time that you have.
And all his area amounts he has received, only 95,000 gratuity is pending.
95,000 gratuity is
Is pending.
This 2 lakh 8,484 is in what connection?
Just the audit has given
It may say 100 and odd things, sir. How he is concerned with that?
he has taken the advance.
He has taken the advance.
Yes.
They say that the advance was taken, it was not
Yes.
accounted for.
If you have taken advance, you don't pay that.
This is of the year 95,
It
96.
may be of 91. If you have taken the advance, that you have to repay.
No, that has already been accounted for.
Where is that? Now you find your affidavit.
During that period,
Where is that? Where have you stated in your petition? You are only
Sir,
making
now-
oral observation. So we'll give you time. You ask your client. The objections are like this. What do you say about para 6? It's a public money.
yes, that is the 30 years back there. Now, where from I'll get those
Or
documents?
if he has taken money, it has to be paid back. It's a government money.
The Rafiq Masih case, your lordship,
That is not question. That is
Supreme
not
Court
the-
says that after retirement,
Rafiq Masih is where wrongly some amount is paid to the lower rank official.
that's yes, recovery of that. Yes.
Not this. The money which you have taken.
Now, for the first time, they are coming after
Therefore,
30 years.
Why can't you understand?
No,
Small things you don't understand.
Yes, I.
You understand? Therefore, now it is served. Have conference with your client. Come back.
May I suggest one thing, your lordship?
Yeah.
So far as this amount is concerned, so I'll get a huge amount from them towards my area pension.
So then the
and-
entire money is paid to you.
No.
Mainly read para 6.
No,
Mainly read para 6.
And we have given the details of amount
And
paid.
money payment is particulars are also given.
Yes.
no, gratuity amount has not been paid.
Yeah, that we have.
That they have said because 2 lakhs, you only have to pay more.
No, 8 lakhs I have to get gratuity amount.
8 lakhs.
8 lakhs.
It is only 95,000.
95,000 I've been appointed since 1990.
I do not know. You file your reply to this.
Yes, I'll.
What do you call it? Counter. What is that? Reply counter. What is that? If you file subjection.
I have the preliminary counter.
Or reply to this affidavit.
Again, one more counter you will file. Again, matter will go like that. This is of 2024. Preliminary note, preliminary, provisional, pre-final, final objection. You have to file a complete objection. May I serve a copy of the objection?
May I suggest my another thing? I'll give an undertaking.
Yes.
So far as this amount, outstanding amount is concerned. So far, this I'll give reply to them. And
File reply.
They will recover that amount.
2 weeks for filing reply to the rejoinder filed by the state district. All of the 2 weeks.
The last of your lordship, last of is directed to the accountant general.
What he said.
There is no cause of action arising in the accountant general. That order may pass.
But other person, no, it will not pass that. It's a pension matter. Whether your officer is present here,
Yes.
call him. Why is he standing there? Ask him to come in the front.
He is the principal.
Principal.
He has forwarded the pension paper.
You have forwarded the pension paper? Yes, sir. When did you forward?
Long back.
Month of 6.
June.
In the month of June. How did you forward this?
So I sir. Online mode.
Online.
Sir.
He has forwarded to the sanctioning authority, not to the. So that miscommunication.
Yeah, but sanctioning authority is sitting over the same.
Because of this amount. And if he undertakes, give an undertaking that he will, it will be deducted from his final pension, we can.
What do you say?
Yes. That will be subject to.
And you can challenge it subsequently.
Yes. That will be.
Right now. The grievance of the petitioner, the pensioner, is as to non-sanctioning of regular pension. Although provisional pension is released, provisional pension
Now will be.
is first off. Learned counsel for the petitioner, relying upon the decision of the apex court in DS Nakara versus Union of India, submits that pension is not a bounty and withholding of pension is unjustified, and therefore this court should intervene to do justice to the right. First, yes, learned DGA appearing for the official respondent and the learned panel counsel appearing for the accountant office of the accountant general submit that ordinarily pensions are sanctioned and punished in a normative way. However, when dues are noticed pursuant to audit objections, unless the same are clear, the pension papers are not processed. First off, learned DGA appearing for the official respondent has also filed a counter affidavit dated 31/7/2025, countering the contentions taken in the petition, and says that if the petitioner agrees to repay the amount of rupees 2 lakh,
If the petitioner undertakes to deduct the
agrees for the deduction of rupees 2,08,484.40, there would be no difficulty for releasing rest of the amount by sanctioning the regular pension. First of all, petitioner, petition counsel for the petitioner is agreeable with this proposal, subject to reserving his right to challenge the deduction in an appropriate procedure. First off, next paragraph. In the above circumstances, this petition is disposed of, directing the which respondent?
The director.
OP number 2.
Director.
OP number 2. He is the sanctioning
authority.
OP number 2, to sanction the regular pension to the petitioner within an outer limit of 4 weeks, subject to the observations herein above made. First off, if delay is proved in accomplishing this mandate, the petitioner shall be entitled to interest at the rate of 1% per mensum for the first 3 months and 2% per mensum for the period next following, and that the said amount may be recovered from the erring officials of the department personally.
And so for a payment of the gratuity, 6% your lordship may get. That is a statutory provision.
No, but the amount when due, when amount is due, that they will work out.
So that is.
I will, you lordship may some direction to the accountant general when the council is there, because they will sanction the
The processing, your lordship directed to the pension sanction authority to submit the pension paper before the accountant general.
Yes.
And accountant general will process the same within.
On the submission of papers by the second respondent, comma, the office of the accountant general shall process the same and sanction the pension.
After submission of the pension paper to the accountant general.
We have said within 4 weeks, next following, failing which that office also will be liable to pay 1% interest per mentions for the initial 3 months and 2% for the period next following, which may be recovered from the hearing officials of the department.
Subject to comply the formalities.
Again, you will raise the subject to if, but they will create lot many problems. We will have many difficulties. Make application. We will clarify them. If any difficulty arises in giving effect to this order, it is open to the parties concerned to move an appropriate application and seek clarification.
All right. With the lordship,
must move the application.
with the lordship permission, if lordship should see this honorable court judgment of Honorable Justice S.K. Panik, they have dealt with all the Supreme Court decisions. And
Yes. Next.
you lordship disposed of.
Disposed of.
This order.
Last directive has not been reflected in the wrongly rather. No.
Item 4, my lord. Item 4, my lord. I may be pardoned to mention, my lord. Item 4, due to some communication problem in VC, my lord. I could not, my lord, connect, my lord. Item 4, my lord.
Yes. What do you want?
My lord, I want that in this connected case, that so many order has already been passed by this honorable court for the other persons, my lord, other petitioners. So I pray, my lord, next week, this matter may kindly be listed next week, so as I am able to file the copy of the similar order passed in the similar nature of cases, my lord.
2 weeks at the request of counsel for the petitioner. Yes.
Oblige, your lord.
By please, your lordships.
Yes, sir.
My lord, the petitioner in this writ application challenges the action of the opposite party in not accepting the application form for issuance of the death certificate, my lord.
Death certificate.
Yes, my lord.
Last has happened.
My lord, I
Death
have.
has happened.
Yes, my.
In normal circumstances or abnormal circumstances, unnatural circumstances.
My lord, he has died in an unnatural circumstance, in an accident, my lord.
Accident.
And the last of the journal, this lordship has directed the London State Council to take instruction in the matter, my lord.
Yes, I have received the instruction.
Death certificate, even death certificate, you will not issue.
No, he has not my instruction, which I have received my lord yesterday, that he has not submitted the required documents.
What documents?
Your lordship may see.
What are the documents? Do you have state rules under the Registration of Births and Deaths Act?
Yes.
State rules?
Yes, my lord. That is.
What they say?
My lord,
What documents are to be produced for issuance of death certificate? Money to be paid.
There is a discrepancy in the Aadhaar and Aadhaar of the deceased father.
What is the other discrepancy?
Name. The father's name is different.
What is that father's name? Whatever is there in Aadhaar's card,
Yeah.
if that person is dead, still you will not declare him as dead.
No, my lord,
His certificate.
my lord, I am just clarifying one thing, my lord. The present petitioner is the adoptive father of the deceased, my lord.
Adoptive father.
Yes, my lord. In the annexure 1, my lord, in the school certificate, name of the present petitioner is reflected there, my lord.
No, under the Births and Deaths Act.
Yes, my lord.
Now, who should report birth and death?
But it is the by virtue of the death information certificate under annexure 2 series at page 14, my lord.
Certificate is given by whom? By hospital.
By the hospital, my lord.
Hospital has sent the certificate saying that certain postmortem reports perhaps they have referred to. What else is required?
No, my only instruction I have received, if your lordship say, direct me to file affidavit. Here it is written that the documents provided by him were incomplete and insufficient for uploading onto the birth and death registration portal of Orissa.
What are the documents you need?
My lord,
What are the documents you need?
That detail is not here.
Then how we should tolerate such officers?
Only your lordship wanted to take instruction, only this much by way of a letter this has come. If,
The death has happened.
yes.
That is unnatural death,
Yes.
an accident. Even there he will not show the mercy.
Machine is some procedure.
What is the document
Yeah.
you tell? We don't know. If you tell those documents, I will tell him to produce them. The registrar of births and deaths shall be present before the court on Tuesday personally at 10:30 a.m. to answer certain questions which remain unanswered in the affidavit. Have you filed the affidavit now?
No, I have not filed. Only instruction I have received by way of a letter. I'll file affidavit. Your
They
Lordship.
remain unanswered when put to the council appearing for the state. First, next paragraph. However, his presence shall not be required if he does the job in terms of the prayer of the petitioner in the meanwhile. Then make it mistake. If he does it, he need not come. Otherwise, he has to come here. I will cross-examine him.
Your Lordship, give some more time.
What for more time? Death has occurred. He has to register the death.
He is not supplying the
You
document.
are not telling what documents.
Item 6.
Here it is, my lord, name of the deceased father, he has written one and the other says something else.
Who sent the report, postmortem report to you? The doctor has reported. There is statutory duty
Yes.
on the hospitals and on the others concerned maternity homes to report death and births. It's a mandate. Nobody need report it. It's a case of unnatural death. Since it's a case of unnatural death,
Yes.
there will be complete whole lot of records with the jurisdictional authorities, police, and with the hospital. There will be FIR, and police would make some inquiry as to Aadhaar, ration card, etc. Because they have to send that to motor vehicles tribunal. I do not know what is the procedure in your state. Then postmortem has taken place. Postmortem report is there. Name, father's name, age, everything will be available.
Petitioner had to supply all.
Why he should supply? You register it first. He will apply for certified copy.
No, he will supply, then it will be uploaded in the portal, my lord.
Which rule?
my lord, I must.
Keep quiet. Kindly be seated. You do not know art of advocacy. You are a child in the bar. Yes. Which rule? Tuesday at 10 a.m. he should be. In the event if Wednesday, in the event if he does everything, he need not come. We have made it. Whatever may happen. Okay.
Item 6. May I please, your lordship.
5 or 6.
My lord, matter relating to
Ah.
sanction of subsidy under CAE scheme. The petitioner is a scheduled caste person who availed a loan under CAE scheme. As per the provision of the scheme, petitioner is entitled to get 50% subsidy.
Where is that?
My lord, make annexure. Annexure 3, my lord.
Huh?
My lord, may kindly see annexure 3, page 11.
Annexure 3.
My lord,
What is this?
after successful establishment,
For subsidy to the tune of 50% of the project.
my lord.
Limited to 50 lakhs. You shall be executing the project through bank finance. Did you give the representation?
My lord, OP number 3 issued a letter to substitute the GST vouchers. I have already submitted the GST vouchers by the annexure 5. But
No, where have you given the letter? You give subsidy to me in terms of this. Where is your letter?
annexure 6, my lord. That's the English version. English translation version of the annexure 6.
Yes.
That is pending before the OP number 1. OP number 4, my lord.
What do you say, brother? You consider this representation in terms of the scheme.
Yes, sir.
It is made in 2023. More than 2 years, 2 months are over now.
5 lakhs was sanctioned in his favor for establishment of Aquashop.
He has given a representation. You can say reject the representation. Or you can say give him the subsidy.
We have already received the parallel comment. Your lordship may dispose of.
Good. The short grievance of the petitioner is as to non-sanctioning of the subsidy in terms of the extent policy under which he claims to have accomplished the project, despite giving representation dated 9/5/2023, a copy whereof avails at Annexure 6. Next paragraph. Learned AGA appearing for the official respondent, having resisted the petition for some time, now fairly agrees to instruct his client to take a call on the subject representation in a time-bound way and on merit if all contentions are kept open. First of all, this is appreciable. Next paragraph. Writ petition is disposed of. Time for compliance is 6 weeks, which will include informing the petitioner result of consideration of the representation. First, now, no costs. At the next level, we will impose the cost, heavy cost. Next.
Item 7.
May I please, your lordship? Well, the petitioner is the father of the petitioner, while serving as a junior clerk, was died on 6/8/2011, my lord, while in service. So the petitioner, being the son and legal heir, my lord, he has applied the authority as per the proper application for appointment under the Rehabilitation Assistance Scheme on 10/1/2012, my lord. And that is still pending. They have not taken any decision. In the meantime, the new rule came into force. And thereafter, the amendment rule, Annexure 8, page 20, your lordship may see, recently on 4/4/2025, wherein it has been stated that the pending cases of prior to the rule will be decided as per the old rule governing on that during the bill. So my limited prayer before your lordship may dispose of with direction to the
Not the grievance of the petitioner, a son of
the deceased
an employee who died in harness is as to non-consideration of his application for appointment on compassionate ground. First, learned counsel for the petitioner submits that in a category of decisions, the apex court has held that
recent Odisha case,
the applications of the kind have to be considered on a war footing since
in the rehabilitation
death of breadwinner of the family, and the family would be facing several difficulties on account of that. First one. Next paragraph. Learned DGA on request appearing for the official respondents, having initially resisted the petition, now agrees that he is inclined to take a decision on the subject application within a reasonable time and in accordance with law if all contentions are kept open. First of all. Next paragraph. One sentence you have to put. it is not a happy thing that applications of the kind are kept pending eternally, which this court has been noticing in several cases. First off, such a long pendency would defeat the very purpose of the rules which provide for compassionate appointment when breadwinner of the family is dead and gone. First off. Next paragraph. Be that as it may, one sentence. In the above circumstances, petition is disposed of. Time for compliance is 6 weeks.
OP number 2 and 3.
Anyway, he knows which one. 6 weeks. First one. Delay shall be viewed very seriously, and at the next level of the litigation, heavy costs may be ordered, personally payable by the erring officials. From a yes,
From 8 below, the impugned is inaction of the opposite parties in reimbursing the admitted dues that accrued in favor of the petitioner.
in reimbursing the accrued dues.
The dues that accrued on the respondents, they are yet to reimburse the same on me, Milord.
You said exactly the reverse of that. Anyway, where is that? What dues they are?
Milord, I was assigned with a skill training program to SC/ST people, and 10 lakhs was given as Milord first installment. The rest was 20, another 11 lakhs were to be paid after completion of the work.
Now work is completed.
Work completed.
Skill training is over.
Over, Milord.
How many
Documents,
skilled people have come out?
Milord, it is targeted 12 batches.
Each batch comprising of?
Each batch comprising of, it is around 120 students.
Where is that?
That is,
Did you go
in
for
honest,
the skill training?
Milord?
Did you go for the skill training? You have to answer it from the papers.
No, I have not.
You have not. Then on what basis you say 120 people?
Milord, I am for the NGO who was assigned with the job.
Where is that number? Each batch will comprise of 120 people, you said. Or on the
12 batches, Milord. It is
you said that. My
12
question
batches.
remains unanswered. Shall I repeat the question?
Milord, your specific query is that how many students came out? Probably
Each batch,
Milord.
how many students?
That I have
How
not
many
clarified in
pleadings?
my pleadings.
But you said some number out of the blue. Why, brother, why that is not raised? Any representation is given?
Demands is against the Union of India.
Union of India.
Milord. They are two. In fact, Milord, 2 sets of writ applications were filed. And this,
Where is the obligation to reimburse?
your Lordship may kindly come to page 24.
24.
Milord. After I have given all the documents, Milord, this is an intra-departmental communication.
Where is that assurance that you will be reimbursed?
Milord. Several communications are there, Milord.
Not communication. One sentence you show me. Whatever expenditure you have.
Your Lordship may kindly come to Annexure 5. Shall I read, Milord?
The relevant portion you read.
This office has received gist of expenditures in respect of...
Not that story.
Milord.
Where is the assurance by the Union of India that you will be reimbursed?
1, 2, 3, 4. Fifth line, Milord. From the top. With the recommendation for reimbursement release of 7,48,000 and rupees 10,86,000. This is what my claim is. And in respect of that 7 lakh, another writ application is pending in favor of said organization. Unfortunately, the original documents were above
Pays for the opposing parties. You pay.
Union of India.
For Union of India will appear.
They're in virtual mode.
Yes, sir. Unmute your system.
Most likely that of single bench.
My lord.
Stop. Registration verify. And the next
It has been, it has come out the first time I will take instruction. However, there has been an annexure 5 which shows that the certain documents have been sought for from the petitioner that has not been submitted. However, your lordship may allow me short time so that I can take instruction whether there is an entitlement and why this entitlement has not been stopped as of yet.
You notice, learned, who are you? What is your designation?
My lord, SS question along with learned DSGI.
So DSGI accepts for first respondent.
My lord, respond number 1 to 3. Open number 1 to 3.
1 to 3.
My lord.
State is a party.
Selected AGA on request accepts notice for 4, 5. Development Commission 4 and 5.
Government of India. That is.
You appear for 1, 2, 3, 4, and 6. DSGI has to appear
1, 2, 3, 6.
6.
My lord is correct. 6 also, yes.
AGA for others.
4 and 5.
4 and 5.
Yes.
Okay. Call this matter in the first week of September 2025, since a short issue is involved.
Shall I make an additional prayer, Miller?
Yeah.
Another connected writ application is pending in which your lordship has already issued notice. Let that be tagged up.
Call this matter along with WP number so and so. Yes.
Item 9. Item 9, Miller, I am on virtual mode. This matter has become infectious, Miller. So I pray this may be permitted to withdraw, Miller. I have filed a memo, Miller.
Learned counsel for the petitioner has filed a memo dated 1/8/2025 seeking leave of the court to withdraw the petition as on the ground that it has become infectious. First, ordered accordingly and writ petition is disposed of. Show the government of the house.
Item 10.
Registry to send a copy of this order. Your all representation respondents, your appeal.
Yes,
Then may not be present.
State.
Item 10.
May I please, yours?
Yes.
Petitioner is the principal of Kasinath Higher Secondary School. Because of non-depositing the EPF contribution of the employees in time, the EPF Regional Commissioner, EPF Authority, manner under Annex 3, they attached the bank account and minor.
If you do not contribute, what they should do?
Minor. What I humble so during Corona period, from 2000, the period from 6/4/2019 to 2/2/24, my lord, the total, my lord,
Corona period is from 25/3/2020
my lord,
to 23
to 22.
3/2022.
In between, my lord, Corona period plus other general after Corona period, my lord. The total period is 6/4/19 to 2/2/24.
6/4/19
19 to 2/2/24. Total amount, my lord, 28,90,000 odd. We have deposited 16,66,000. My lord.
What about remaining amount?
Remaining amount, my lord, I have mentioned 12,15,000.
Now that you have to pay.
My lord, your lordship gave some installments, so that was the.
Show me the power of the court to give installments.
Earlier I approached before.
I am not the banker.
Earlier I.
The law. The court can grant any of the high courts in the country.
My lord,
have they given installment?
Earlier I had approached before this honorable court because of defaulter. This honorable court granted some installment basis. I have also.
That I will not follow. We are not Mughals. We are judges. We have to decide the cases according to law, not seeing face, etc. You show me the power. We will give you the relief. We can't decide based upon the faces, etc.
Well, I am not saying
to decide on law. Show me the law.
Well,
I will walk any length and give you.
Not only I do 2-3 installments. So lordship fix as your lordship.
I'm asking. I sympathize because I have seen what happened, what has happened during Quran. But where is power? Sympathy is one thing. Having power to do things is another.
My lord, your lordship is right. But your Lordship, can you see the earlier order one for a moment, my lord? Annexer 2(1), page 13, my lord, starting place page 13, my lord, of this annual report. I have cleared the dues.
Cleared, but rest of the things you are not clear.
Therefore, because of Corona, we could not collect the fees from the students and.
Corona cannot be chanted like mantra unless you show the law, some policy, some decision, some rule. We cannot come to your aid at all. Nothing is said in that judgment. I just read that judgment.
That judgment only
no law is decided. Simply the learned judge has given you some relief. We don't agree with that. I don't agree with that. Any relief has to be based upon normative way approach.
Only my lord, 2-3 installments, your lordship permit me to authorize the entire amount deposit, entire salary deposited in that account that is attached. You could not release the salary of the employee, my lord.
The clause is that way. What to do?
The lordship will consider the only one this year.
Who appears for
my lord?
My lord, I am appearing on behalf of Dr. Purushottam Churi. My lord, counter affidavit will be filed today, so
2022 matter. You have not filed any counter affidavit.
25.
25 matter. First time it is.
No, earlier the lordship directed this coordinated bench of this Hon'Ble Court directed on 22/7/25. Directed
22/7.
My lord, 22/7/25.
They want to file the affidavit, na? We'll give one more week to them.
My lordship.
pass over to after lunch. We will file.
Issue notice. Who is the panel counsel?
Dr. Purushottam Churi.
Three so. Panel counsel on request accepts notice for which respondent?
My lord, Regional Provident Fund Commissioner, EPFO.
Only one.
One, two, my
One respondents. First now. Learned counsel for the petitioner pleads COVID-19 as a ground for relaxation in the matter of discharge of the amount due to the state, due to the respondents. Matter lies in a narrow compass, call week after next.
Item 11.
You have a word with the council also. In similar matters, how various high courts have treated COVID. Is it a vis majore or act of God or act of Superman? How they have treated? Just look into. There are judgments. None appears for the petitioner. All after 3 weeks. Next.
Item 14.
Yes, sir.
Wait, please, your lordship. But the petitioner is a poor man, a small vendor who was having a shop, this kiosk, allotted by GCIT, Greater Cuttack Improvement Trust, way back in 1886. So he had run the shop, which is a small betel shop and that unpaid milk distribution center and all those things. The road was to be extended, in fact. Your lordship knows near the Baravati Stadium, opposite to the stadium, that playground.
Yeah.
So a lot of people have been allotted kiosks. So after that was, they were required to be evicted from the place for expansion. So here also the notice was given him to leave that kiosk and so that road would be expanded. Initially he filed a writ application. The Annexure 3 is there. Hon'Ble Court eventually...
So you want alternate land?
The courts also observed. You approach the authority. Since you are running for 40 years, 50 years, so you can give an alternative site. There are alternative sites, others have been allotted.
That means like you.
Like me. I've also given a copy. That time instructions, they are saying that no, we will not do it because they are the authority. If they say no, I can't have any say.
Have they said no? No.
So they have said no, will not be considered. But
what is your right?
So right, there is no right. But
no right.
But we are given the license. Fact remains, the last 40 years it was there, but it is available, they have given to others. So disparity is there. You also may consider, he's a poor man, he can't do anything because he has to survive actually for livelihood.
Have you allotted to other people?
Yes, that's right. I've given an example, my lord. I've given a copy.
First time it has come. And this is Municipal Corporation and Development Authority there.
Issue emergent notice. But AG is requested to accept notice for first respondent. Correct?
My lord, so one, two, three. One, two, three.
Four. AGA for issue emergent notice to the other respondents.
5 and 6 notices to go.
Yes.
This is
the written importance.
Yes.
Item 16.
This is my lord. The petitioner was appointed as a PG teacher in the 1993. What happened? 1993, my lord.
93.
The school and notable receive granted in 1994. Services other staff approved, 2 teachers not approved on the plea. The certificate not equivalent to Odisha BD. So we are allowed to B.Ed. So we are allowed to undergo training as in-service candidate. 2003. After completion of the B.Ed, they approved the authority for approval of service opinion number 3. No action taken. I approved on tribunal, state tribunal 2006, madam. 2006, 2% approach. One case allowed, they get the benefits. He get the benefit. 9 cases unfortunately dismissed by tribunal. I approached minor this one in FO. FO number 659 2009. FO was allowed in my favor. And remanded matter tribunal to decide matter afresh. Tribunal again disposed of the matter 2023. Allowing my claim. Allowing my claim for approval of service and release of salary.
Allowed.
But
why are you here again?
Till date they are not releasing my father. On the plea.
Where is that order?
That is matter at page operating party matter.
My lords, I have preliminary objection, my lords. There is alternative remedy available
for execution.
This is not the executing court.
No. That
and the prayer.
Notice is filed.
Yes, not filed. Notice is
up to 2000.
So thereafter, kindly.
You still direct disposal of it.
He is right.
Kindly see page 40.
See that. See the prayer.
Prayer. Yes.
Read now. Slowly you read.
Yes,
so that
madam.
Your friends also should hear.
And I should to approve the service that
No,
it is not
correct. Correct. Fully you have to read.
The direction shall not be issued to approve the service petition.
Shall not be issued.
No, why it has not issued? Why it has not issued? As to why it has not issued to approve service petitioner against the post of PG teacher of Balama Andheri High School with April 114. As for the judgment of State Tribunal that so-and-so party in jail so-and-so and 7, which was confirmed by this only FO number 330 of 18,023. FO also dismissed. And release all his areas release Indian House of Superannuation Service. Since superannuation 30th April 2025.
You have order at the hands of tribunal. And there is that order is made in terms of FAO.
FAO dismissed, filed by opposite parties.
That's what I'm telling. Now we have filed the execution also. But direct the executing court to dispose of the execution within 6 months.
They are only started in execution court. Then FO is that after dismissal FO, readable has been filed. Readable minors not that readable against FO not maintainable. This one, the footprint, this one court, minor also in this.
That I cannot decide. Whether writ appeal is maintainable or not, can I decide?
They are only
have to decide.
They are only stand in the execution court that the writ appeal is pending. For that reason,
then we will say dispose of the writ appeal.
No. I only pay either manner to dispute. I have retired in the meantime. I have not getting also pension because not on approval.
That's all.
My only prayer, let the approved service or lordship directly execute execution the tribunal within the specific period, my lord.
Correct.
I return in
We agree. What is that execution number?
7 of 2023.
23.
Execution case number
7.
in page 3, para 1.
I mentioned, my lord.
Right now. Petitioner is knocking at the doors of Red Court with the following prayers. First, prayers are not happily worded. First, be that as it is. Next paragraph. Learned counsel for the petitioner, having argued the matter, now agrees with the proposal of this court that petitioner's execution case number 7 of 2023 itself can be directed to be disposed of in a time bound way. First up. With this proposal, learned AGA is also agreeable. First up. Next paragraph. The apex court in Rahul Shah versus so and so has held that all execution proceedings should be disposed of within an outer limit of 1 year. Inasmuch as right to speedy justice is a facet of Article 21 of the Constitution of India. First, in view of the above, this petition is disposed of, directing learned judge of the executing court to dispose of execution case number 7 of 2023 within an outer limit of 6 months and report compliance to the Registrar General of this court. First, non-compliance may result into an adverse entry being made in the service register of the concerned judge. First, all contentions kept like that. 17. Yes. 17. Rahul Shah. Can anybody give the citation? Rahul Shah versus so and so, apex court decision, Mr. Mohanty. Just look into it, give that judgment.
This rate is regarding a unauthorized construction.
Shah versus some Gandhi. It is. Just look into it. Yes.
This rate is regarding a removal of an unauthorized construction.
Why?
This rate is regarding demolition of an unauthorized construction matter. Unauthorized construction is made by the opposite party number 4 in the public road, on the public road matter. So the petitioner protest him, and on that basis, the UAP case is filed before the appropriate authority, that is a BDA, for removal that construction matter. That was
for removing the illegal construction. What is that building?
Building matter.
So when the building was put up?
Pardon me.
When it was constructed?
It was constructed in the year 2002 or 3. I have
Where have you stated? Where have you stated in the petition?
That was actually not within my knowledge, but that was constructed before 2015, my lord.
What is the age of your client?
This dispute was asserted before this Hon'Ble Court earlier in WPC number
what is
at 30412 of 2023, and in that writ petition, and this Hon'Ble Court, after considering the grounds of the writ petition, passed an order for demolition of the unauthorized constructions.
You need implementation of the order passed by ODA court in UAP case numbers. So, is there any execution mode for this?
My lords, in fact, the answering party is the municipal corporation, my lord, and BDA. And there is a private party also included.
Let notice go.
Why notice should go? Why it should come? Because we have to decide whether there is encroachment or not. Suppose if the encroachment was done before birth of
An
the
order is passed by passed in the UAP case for demolition of this unauthorized construction after disposal of the first writ petition. And that order wasn't carried out till date, my lord. Despite the order of this honorable court, thereafter the petitioner filed a contempt case. And
what happened to contempt case?
In that contempt case, one part of the order is complied, my lord. That is regarding the UAP case. The UAP case is disposed with a order of demolition of the unauthorized construction. But the next part, the demolition of the unauthorized construction on the public road is not carried out.
But that is not part of the UAP order.
That is part of the UAP order.
That's part of the UAP order.
My lord. But till date it is not complied. Which was the part of the first order?
Issue emergent notice. Let the AG is requested to accept notice for the which
one only.
Response number 1. Emergent notice to the rest. Retrievable within 6 weeks.
Item 18.
This matter relates to 21 selection.
SCC.
Yes. 2021 SEC
6 SCC 418.
418. 41.
May I please allot?
Yes.
This matter relates to selection of that guest faculty, my lord. In this case, the present petitioner challenges the inaction of the opposite parties with regard to the engagement of the OP number 7 without publishing the result, my lord, of the selection list. That is clear in violation of Annexure 2 at page 20, my lord. Yeah. On 21, 2025, my lord, this honorable court has pleased to direct this. No, to obtain instruction. Directed the London State Council to obtain instruction.
It will come after notice.
No, my lord. Before notice. Fresh admission, my lord.
So notice has to go.
Yes, ma'am.
Issue emergent notice. Learned AGA is requested to accept notice for
OP number 1 to 6.
All.
No, OP number 7 is the private party who has been selected.
Emergent notice to OP number 7. All are 8 weeks.
In this case, I have filed an IMI.
Along with
IMI because he has been engaged, subject to result of the REIT application. I filed an interim application.
Interim application for?
With regard to, because he has been appointed OP number 7 in violation of Annexure 2, my lord. I pray, my lord, his selection is subject to result of this REIT application.
The appointment, selection and appointment of OP number 7 shall be subject to outcome of the REIT petition.
Obligement.
Item 19.
Wait, please, my lord.
Yeah.
Item number 19 and 20, both are identical matters. They were allotted with residential plot.
Take notice. Issue emergent notice. Learned AGA request accept notice for respondent numbers 1, 2, 3, 4. Emergent notice to 5 and 6.
My lord, obliged.
Item 21.
20 are not called.
Item 21.
May I please your lordship on behalf of Mr. Bahali kindly pass over. On behalf of Mr. Bahali kindly pass over.
Pass over.
Here, my lord, 21. It is in respect of the appointment of a student under the Adarsha Vidyalaya. On the score that there are some percentage of seats is reserved for the government employee. On that score, this has been rejected, being not considered that he is not belongs to that category. So from Puri Collectorate that we have to ascertain. So may I pray it will be Monday, Tuesday or Thursday I can collect it.
Call next week at the request of Learned AGA one. Yes.
Item 22.
May I please, your lordship? I am in EC, your lordship.
Yes.
And in this case, the petitioner challenging the illegal and arbitrary action of the opposite party for not providing the original marks certificate of clause 2. My lord, the fact of the case is that, my lord, the present petitioner was passed HSC exam in the year 2018, my lord. Yes, my lord.
They are not giving the
Original pass CSC certificate, my lord. The fact is that, my lord, kindly have a glance.
All right. You have to glance me also. We'll order notice.
Yes, madam.
Okay.
No, this is for the +2. Panel of lawyers are there. If the senior advocate, Mr. Rao is appearing. If at all they will serve a copy, then it will be more easier. Because of the students.
Emergent notice. First one. In addition to taking usual steps, copy of the petition will be served on the panel.
Copy number 2. Mr. Rao, Sudhakar Rao, is this enough?
Sudhakar Rao, appearing for OP number 2. Post immediately after service, since the interest of students is involved.
Prafulla Ratha, I'm sorry, Prafulla Ratha, P.K. Ratha.
Prafulla?
Kumar Ratha, P.K. Ratha.
Right on that name.
I beg pardon. That school admission matter.
School admission matter.
Yes.
That which was passed over, but I have made a mention.
Tuesday we will have that. 21 Tuesday. At the request of you want some time.
Because admission session is going to over.
Correct. Yes.
Item 23.
What is this matter, Mr. Gandhi?
This is in nature of, in fact, PIL, my lord.
Dispose of the representation.
Representation of the representation, my lord. It is the representation is annexure of 5 and 6, my lord.
In which what he has sought for?
They are seeking one direction that one watchman who is working in a different
against OP number.
Exactly. That's in service law. This is a third party, so to say, trespasser. He is posing himself that I am a social worker and all other things.
Anyway, we can direct them to consider representation. But
Annexure 5 and 6.
Short grievance of the petitioner is as to non-consideration of his representations dated 26/2024, wherein he has sought for some action against OP number 5, to whom notice is dispensed with, since no positive order is being issued against him. Next paragraph. Learned AG appearing for the answering respondents submits that such a representation is thoroughly misconceived and it is and the petition does not deserve any consideration. Having so contended, he agrees to ask his clients to look into the grievance of the petitioner as has been aired in the subject representations within a reasonable time. First off, this is appreciable. Next paragraph. In view of the above, petition is disposed of, keeping open all contentions of the parties. First off, it hardly needs to be stated that if any action to be taken in terms of the subject representation, OP number 5 shall be notified.
We given opportunity for that.
Opportunity shall be notified and given an opportunity of hearing.
Item 24.
May I please, Your Lordship?
24. Yes, brother.
Your Lordship, in this red petition, the petitioner prays for a direction to the OP number 2 for the regularization of a service for which he has filed a representation before the OP number 2 wide Annexure 3 series based upon the orders of this very court, which is in Annexure 2. Based
Will
upon
you be happy if there is a direction to consider the representations in terms of order? But
the petitioner has been retired since 39/2020, and he seeks for the regularization so as to get his equal adherence allowance, and all that there is pending.
Petitioner an employee who has been superannuated on attaining the age of retirement is grieving against non-consideration of his representation, wherein he has sought for regularization of his services ex post facto. First. Next paragraph. Learned counsel appearing for the petitioner argues that the regularization in terms of the representation needs to be accorded to his client in as much as it has something to do with the terminal benefits. First one. Next paragraph. Learned AGA, Mr. Mohanty, on request appearing for the official respondent, having resisted the petition on the ground that the petitioner has already demitted office, the question of consideration would not arise, would in all fairness submits that you would instruct the answering respondent to take a call on the subject representations in accordance with law and within a period of 8 weeks.
There will be OP number 2.
OP number 2.
Because they are under the Utkal University.
Not you.
No, my lord. We are the department, government, but the answering respondent will be 2 who will dispose of the repension before whom it is kept pending.
But you can send an intimation.
They have already under Annexer 3. They have repented the authority. That can be well considered by the authority concerned, who is added as OP number 2.
Then OP number 2 is
the Vice Chancellor, Utkal University.
Then notice has to go perhaps.
This can be disposed of also. They can consider the same.
So we are only directing them.
Exactly. OP number 2.
May I make another submission, Your Lordship? Your Lordship, the petitioner is covered in the same footing with OGC number 13,599.
They can agitate the same before
and the repention.
You have said that.
Yet, but time and again.
Who appeal for the panel council? Who? You bring panel council.
Mr. Tarananda Patnaik.
Bring Tarananda Patnaik. I'll ask.
He will appearing before this Anuko.
Court is waiting for.
Okay, yeah.
Go ahead. Recall that. First paragraph, maybe. The second paragraph, just like that. Go and bring. Wait, if this pending unnecessary. Yes.
Item 26.
26.
25 adjourn.
Yes. Yes.
Petitioner is a IT training provider and enters into an MSA, Master Service Agreement with STPI, Government of India Autonomous Body under Ministry of Electronics and IT. In the way back 2016. And with a request, and he was floated the tender and he was selected the bidder. So after while entering into MSA, he has deposited also 5 lakhs rupees as the premium bid money, and he started in the month of September 2016. This is viable.
We take notice.
Yes, sir. This is OP number 2 is OP number 1, 2, 3 can be given. Precisely OP number 2.
You take notice to everybody.
Okay.
Issue emergent notice. Any panel council are there?
Pardon?
Any panel council are there?
This is Government of India. OP number 1 is Secretary Electronics and IT, Government of India, who is DG Software Technology Park.
Anyway, emergent notice. Returnable within 3 weeks. 4 weeks. Yeah.
Item 27.
My Lord, petitioner challenges the order dated 1/7/25, my Lord, by the Annexure 6, page 24, wherein the earlier, in pursuant to the earlier order, he had filed the repentation that has been cancelled.
Presentation for?
Regularization of his services.
How many years of service you have put in?
He is working as a Shiksha Sahayaka since 2004, my Lord.
Since 2004?
Yes, ma'am.
21 years?
Yes, ma'am.
Mr. Monty, take notice.
Notice to be issued.
Learned AGA is requested to accept notice for all respondents.
Yes, ma'am.
This response. Call in the 3rd week of September 2025.
28.
My lord, if the IO is there, they may terminate, my lord, I have to.
You're still continuing?
Yes, ma'am.
The services of the petitioner shall not be terminated without the leave of this court.
Yes.
Till next date of hearing.
Item 20.
This interim protection is
similar
to the petitioner, who is said to have put in more than 2 decades of continuous service as the Shiksha Sahayaka.
Sikha Sahayaka.
Shiksha Sahayaka.
Item 28.
Please to your Lord similar.
Yes.
My prayer is at this page 7.
This is all the way, my lord, it is covered that rehabilitation assistance scheme, where my lord says pass the order 90 and 2006-9 that has been overruled. And Jitta Luha is the judgment of the Honorable Apex Court, wherein it has been decided. But prior to that, this Honorable Court has been passed the order. That is the covered.
Covered in his favor.
In his favor.
And annex all these.
Can we dispose of the matter?
Yes, exactly.
Petitioner is knocking at the doors of the court with the following principles prayer. With the following prayer. First up. Next one. Learned counsel appearing for the petitioner submits that the subject matter of his case is substantially similar to the one in which is that judgment.
My lord, that judgment is also annexed by my learned friend at page 34.
Page 34. Page 34 and Annex 8.
In
State of Odisha.
Civil Appeal number 584242 of 2025 and other connected matters between State of Odisha versus Jita Luha, disposed of by the Apex Court by the order dated 2/5/2025, and therefore the relief in terms of division bench order of this court. This court will.
Yes. Prior to that, your lordship has passed the order while sitting in the division bench. Exactly that verbatim Supreme Court has passed this order.
Okay.
That we have given that order also.
A coordinate bench decision in. What is that coordinate bench decision?
We have given 2 to 3 occasions. This Honorable Court. While sitting with Malad Justice Sao.
This went to Supreme Court already and
no, Millard. While amending in 4/4/2025, so far the 6/9 of this rule of rehabilitation, that was turned down because the pending cases which is to be considered as per the 2020 rules, that has been struck down. Man.
So then relief has to be granted in terms of Apex Court decision only.
Apex Court decision.
And so. And therefore, the same relief needs to be granted to his client. First. Learned AGA appearing for the answering respondents. So initially resisted the matter for some time, now agrees that the case of the petitioner is substantially covered by the said decision of the Apex Court. First, next paragraph. In the above circumstances, relief petition is allowed in terms of the decision of the Apex Court supra. First of all, how much time to implement the order?
3 months, my lord, because it is in the process, my lord.
A period of
the application.
A period of 3 months is fixed for extending
the government is in process.
Petitioner, as has been extended to other similarly circumstanced employees who were respondents in the before the Supreme Court.
Your statement is opinion number 1 and 3 only.
We have said shall be implemented.
1 is the commissioner, 3 is the
government will take a policy decision because all the way this has been admitted by
commissioner opinion number 1.
he is to take the decision and OP number 3 to implement.
It should be implemented. It will help you.
You also may specify that the OP number 1 to take a decision, then OP 3. Otherwise,
we should take. We said the relief should be extended to the petitioner within 3 months. In terms of
3 months, ma'am. 3 months.
3 months.
3 months.
3 months. Yes.
Item 29. Then, my lord, I submit my lord. Suppose they have not implemented.
Then contempt against everybody.
All the.
That helps you. We'll have one more accused.
And my lord, item number 32 also same.
32?
32, same. Forward with the 32. My lord, also not. 32, my lord.
I believe you and I'll pass.
Yes, my lord. My lord, I have given the judgment also.
Item 29.
Wait, Lordship. Item 29 needs an adjournment.
29.
Don't. Adjournment. Don't. Need timing. Yes.
2 weeks. The request.
This is, my lord, the innocus prayer is that illegal confinement. The daughter of the petitioner by Baba, so-called Baba. So they have lost this affair before the authority concerned. I think that keeping in view the urgency, let that be a direction without adjourning the same. It is for the interest of the petitioner. That I am.
You should appreciate his fairness.
So if at all they are in stake, though at the earliest the direction should be given by that interest of the petitioner will be protected.
Petitioner is knocking at the doors of a court with the following prayers. They should be recalled from which? Whose custody?
In OP number 5.
OP number 5 is who?
His name is Tutu Baba alias Biswajit Sahu, aged about such and such, address is such and such.
Notice has to go if I want to pass it.
Well, police can take the rescue operation. In fact, Baba, Guni, Tuni, these are the allegations. I have gone through the details. Police is to take the action, in fact. Keeping pending. They have made the OP number 4 as a party. IIC, Kamakhya.
What kind of prayers, brother? How have you drafted the prayers?
Lordship, I don't have any idea about this. My senior is listening.
Though the prayer is nationally drafted, after perusing the petition papers, this court gathers an impression that 2 daughters of the petitioner, correct?
Exactly.
2 daughters of petitioners are in the confinement of
OP number 5.
OP number 5.
Opposing himself to a Baba.
Who allegedly claims to be a Baba.
Baba.
Baba means what?
Baba means
some saintly figure.
Exactly.
Who claims to be
not sadhu, not sadhu.
Not sadhu.
Not sadhu.
But sadhu.
In the guise of sadhu, they are pretend to be in otherwise manner.
Who is said to be a spurious sadhu.
Exactly, spurious
sadhu. First, learned counsel for the petitioner submits that confinement of are they minor children?
No.
Major. Confinement of daughters is a serious thing, and therefore the jurisdictional police and the revenue authorities should look into the same in terms of miscellaneous case number 11 of 2024. Prayer column page 17.
Yes, we know.
20. First. Next paragraph. Learned AGA, Mr. Mohanty, appearing for the respondents, stands tall at the bar and makes a very fair submission that the jurisdictional authority shall look into the issue and they would swing into action on a war footing.
Yes.
First off, this should satisfy the petitioner. First off, next paragraph. In the above circumstances, and with the above assurance of the authorities given through the learned AGA, petition is disposed of. No course.
30.
Since no adverse order is being passed against the private respondent, notice to him is distanced somewhere before the
Covered by Raymond Kumar Chotra, similar order has been passed by.
This is by the division bench. It is outing on 11/8. So all the matters is posted on second week of September.
Second week of September.
That is the block grant pencil.
The other matters is issue emergent notice. Second AGA, Mr. Mohanty accepts notice for all respondents.
Yes, no.
All respondents. First of all this matter in second week of September. Since related issue is being treated by the
division bench and it is fixed to 11/8.
And that the case is posted on 11/8. Case is said to have been posted on 11/8/2025. Take this.
Item 31.
Manage.
Same order.
Same order. Similar orders.
Same.
Item 33.
May please, madam. Next, sir, 11, rejectment candidature are being appointed as junior teacher, my lord. I have approached your lordship, my lord.
What is the prayer to that?
Prayer, my lord, to COAS Annexure 11, order dated 14/5/2025, and to issue a writ of mandamus directing the opposite parties to engage me as junior teacher, schematic Telugu. The background of the case is like this, my lord.
Similar matters we have issued notice, na?
My lord,
we have issued notice in similar matters, other matters.
I don't know, madam.
Yeah, we have issued, I remember.
Yes, madam.
Who are the your opponents? All government office?
Yes, all government office.
Learned standing council, additional standing council on request of some notice for the respondents. Is he continued or discontinued?
No, he has not been engaged.
He has not been engaged?
No. His candidature has been rejected.
On this matter, second week of September 2021.
But I filed one application, interim application for keeping one post because posts are lying vacant, man.
Are they making engaging others?
Definitely, my lord. Second list will be published very soon. In the event second list will be published, then they may. I don't know whether any candidates are there or not. Out of 11 posts, only 3 persons have been similarly placed persons have been engaged. 8 posts are remain vacant, my lord.
8 remain vacant?
Yes, my lord, still well.
The jurisdictional respondents, opposite parties are directed to keep one post vacant.
Yes,
till next date of
in Ganjam district.
In Ganjam below, till next date of
I love that.
34.
Here the minor, number 2 minor, BMC, initiated a proceeding under 91 of the Act against the petitioner to demolish the second, third floor of his building minor. Subsequently challenged the appeal minor. Appeal also dismissed. My submission minor, BMC cannot proceed also the 91 of OD Act minor because urban planning is under municipal law minor. There is a decision of our own High Court minor. Also, annexed judgment minor.
They have no jurisdiction.
No minor.
Because
you have built the house building without.
Yes, ma'am. There is a permission for second floor.
But you have built
third floor.
third. That
Can be compounded, my lord. There is a first floor. There is a compound.
Whatever provision for compounding.
Yes, ma'am. There is some policy of government is there, my lord, for compounding.
Have you applied for compounding?
Yes, ma'am. I have applied for.
The BMC is the contesting party. Notice has to go.
Let's issue emergent notice. Learned IAC is requested to accept notice for response number 1. First up. Who appears for BMC? Bhuneshwar.
BMC.
Emergent notice to second respondent.
Panel are there.
In addition to taking usual steps, petitioner may serve copy of the petition on the panel line representing the second respondent. First up. Any interim order you have got?
Yes, my lord.
Status quo till next date of hearing.
35.
35.
Yes, sir.
This is a case relating to selection and appointment of a PGT teachers, trained graduate teachers in high school.
No, IA is filed. Brother, no IA is filed. Please call the brother. Wait. No, application is filed. But he said that I was sought for interim order.
IA is filed.
Filed. No. Just looking. 13. It's not surely the list it is not shown. But IA is there. IA is there. Yes.
And the petitioner was successful in the written test. The petitioner was successful.
Make use of mic.
The petitioner was successful in the written test, CBT, that is called computer-based test, online test, and was called for verification of original document. At the time of verification document, the candidature, the eligibility of the petitioner was rejected on the ground that she has not filed the recent caste certificate.
Caste certificate is not filed.
It was filed, but it was old.
Old caste certificate.
It was old certificate.
How long the caste certificate will be valid under law?
It is 5 years. Caste certificate, that is a question. That by birth, if I am Brahmin by caste, can I change it at the age of 40 or 40 or 20? Can it be changed?
You are right.
So, what if this will be the regime and they have snatched away my right of appointment when I have...
You take notice.
Representation is pending.
Huh?
Representation.
What representation?
Representation,
what he says is, once caste is decided by birth in terms of Indra Sahani, by passage of time it is not altered. Karna was treated as a member of downtrodden. Okay, Krishna said, no, you are also son of Kunti Devi. But Krishna, Karna said, that's what you are saying. But the whole world believes that I am a member of a downtrodden community. Therefore, caste is decided by birth. There is, I quoted mantra from Mahabharata. By birth, caste is decided. This is what Apex Code says in Indra Sahani. Caste is not altered by adoption or by marriage. Religion you can convert. You can go to other faith. But caste cannot be. Though that was there, where changing Varna was there, like Vishwamitra became a Brahmi, Kshatriya. Is it not? That was available in old Shastric laws. Anuloma, Viloma, procedures were there. But no, that judgment has not. What he says appears to be sensible. Take emergent notice. Any interim order you have sought for? No interim.
No, this is for the past.
Emergent notice. Returnable within 4 weeks. Any private respondents are there?
No. Item 36.
May it please your lordship.
Yes.
Item 36, the petitioner is educational trust, madam. Educational trust, running different hostels in the different district of the state and providing educational support to the children. The children are residing in the educational hostels and pursuing their education nearby schools.
It's a boarding school.
It's not boarding school, it's a hostel only, where students reside and study in the nearby school. It's a private organization.
It's only a hostel.
Hostel, providing only food, clothing.
Boarding facility.
Boarding facilities. So, in 2019, central government under the National Commission for Protection of Child Rights has provided a rule. I have annexed Annex 2. They have called this kind of hostels as standalone hostel, man.
Standalone hostel.
Standalone hostel, and it was published in 2019. And it was been directed to all the states to implement it, to see that the children are residing in different hostels should be protected. There are certain guidelines, how should be remaining there, what will be their facilities, everything. Regulatory guidelines. Thereafter, what happened? The petitioner applied for the registration. That it has to be registered. The hostels have to be registered. When it was kept pending. Earlier, the petitioner had come before this honorable court on 18/7/2025. I have annexed this the order. Honorable court passed after obtaining instruction from the state, told that district social welfare officer is the appropriate authority. You go and apply to the district social for registration. Accordingly, the petitioner followed and applied for that. But on 22nd July 2025, the application was made. On 23rd, the DSW rejected. The reason is that the procedure has not been notified. Although Leonard AG has obtained in 3 dates that the DSW is the competent authority, still then he wanted that since it has not been notified, therefore I will be not compliant. Whereas one of the districts already has given the registration certificate.
They have issued.
They have already issued. But this Leonard
notice. Because what he says is
only the clarification, notification. Otherwise, order is already there, my lord. Page number, the order may be much more clarified, my lord. Page number 61.
We will issue notice now. I'll let him come out with some reply.
Because here only the confusion. Already order has been passed, my lord.
Then let him look into the papers.
Okay, man. I have filed IA, my lord, for no coercive action.
IA for?
No coercive action to these hostels.
Issue emergent notice. First, learned counsel for the petitioner apprehends some coercive action at the hands of the authorities against his client, in as much as request for registration is rejected, which according to him is contrary to law. First, next paragraph. In the above circumstances, the application having been favored, the respondents are restrained from taking any coercive action against the petitioner till next date of the
Obliged to law.
My lord, 30 or item number 31. Representation under Annex 2 pending. Rehabilitation Act. Same.
Item number?
31.
31 is over now, no?
Over.
Same order as in this one you said.
That is the Sarat Chandra Parida 30. Item number 30, Sarat Chandra Parida.
Not 31.
31 is the Ritanjali Giri. Same order. I'm submitting the order.
To consider the representation
yes,
in terms of this order. Look at 31. The subject matter of this petition is substantially similar to the one in WP number 20855 of 2025 between Ananta, correct?
Kumar,
Ananta Narayana Mishra
Anant Narayan Mishra,
and
and others.
others versus Miss B. Sahu.
Vijay Lakshmi Sahu.
No, state of.
Vijay Lakshmi Sahu. Miss Vijay Lakshmi.
Only like this, huh? Not yet in the state of Odisha and others. Disposed of by the coordinate bench by order dated 17 by 2020, sorry, 1/8/2025. And therefore, Learned Counsel submits that our client would be satisfied if a direction in terms of the said decision is passed on the representation
Under the Annex 2. Is
at Annexure
Annex 2. Annex 2.
First off, Learned Counsel also brings to the notice of this court the decision in Ratanjali Giri.
Gitanjali
Giri
versus State of Odisha.
Elias Paul versus State of Orissa. 2016, 1 ILR 1162 in support of her case. First off. Next paragraph. Learned ASC appearing on request appearing for the official respondent does not dispute the position as asserted by Learned Counsel for the petitioner. First off. It is a rule of adjudicatory process that similar cases should be treated similarly, subject to all just exceptions. First, in the above circumstances, the petition is disposed of, directing which respondent?
Respondent 1.
First respondent. First respondent to consider the subject representation at Annexure A3.
Yes. Opposite party number 2.
A3. Yes. Correct?
Yes.
Why are you not speaking loudly? A3.
Sir.
Annexure 2. Just looking. 2. In accordance with law, within a period of 8 weeks, which should include informing the petitioner about the result of such consideration. First, it is open to solicitor standard classes. Just no. You argued well. Heard about the Learned Counsel. Miss, what is your name?
Vijay Lakshmi Sahu.
Vijay Lakshmi Sahu.
Item 37.
Your Lordship, with regards to item 24, Your Lordship had directed to fetch the panel counsel for the university.
University?
Yes, madam.
He wants consideration of the representation.
Your Lordship may pass orders to that.
Because Your Lordship, time and again, contempt petitions have been filed with regards to Annexure 2. The orders with regards to which the petitioner is in the self-footing. More than two contempt petitions have been filed, and they have been going on with time and again. So,
but anyway, your representation to be considered, no?
Yes, as soon as possible.
Which is that annexure?
Annexure 3. Page 19, Annexure 3, Your Lordship.
Grievance of the petitioner is short, and it is as to non-consideration of the representation at Annexure 3, wherein what you have prayed for?
Your Lordship, we prayed for a direction to consider the representation wide annexure.
In the representation, what you have asked for pulling down any building?
No, for the regularization of the service of the petitioner.
Wherein a prayer is made for regularization of petitioner services. First off. Next paragraph. Learned AGA Mr. Mohanty appears for the first respondent and says that these clients have nothing to do with the subject.
Your Lordship, the petitioner has been retired since 2020.
Well, Learned panel counsel appearing for the OP number 2.
Balance.
2 University, having resisted the petition for some time, now agrees to instruct his client to look into the grievance of the petitioner as has been aired in the subject representation in accordance with law and in a time bound. First off, this is appreciable. Next paragraph. In the above circumstances, petition is disposed of, prescribing a period of 8 weeks for considering the representation and also to inform result of such consideration to the petitioner. First, all contentions are kept out. Next paragraph. It is open to the second respondent to solicit any information or document from the side of petitioner as are required for due consideration of service. No courts.
Most of pleasure, Lordship.
37.
Thank you for coming here on request.
Yeah.
May I please, my lord? My lord, this is a peculiar case where the petitioner, who is a lecturer of a degree college, is seeking parity in payment with a school teacher, your lordship. That's how peculiar this Odisha education system, your lordship. The petitioner was appointed into a degree college.
As a
lecturer. And your lordship may kindly appreciate, since 1989, the state government has not recruited any lecturers regularly in the aided colleges. All the colleges have been allowed to recruit teachers, qualified teachers. So the petitioner was recruited duly by the
after selection.
After selection. In the only once within the from 1989 till 2014, there are no regular selection. That's very interesting in this state. Now, in the year 1992, by one advertisement, the government appointed few junior lecturers with 48% marks to teach in higher secondary schools in 1992.
48% of marks.
48% mark.
How they will teach the children?
That's what it's 92. I cannot now say that they made this rule, and advertisement was floated, and the process of recruitment was completed only in the year 1997. So people joined between those junior lecturers with 48% of marks.
Anybody from those colleges has become a lawyer here. You may ask any judge also. Anyway.
Now, interestingly, my lord.
What is your prayer?
Prayer is that they gave financial incentives, financial upgradations, the government. And they gave financial upgrades.
Prayer.
That's what I'm saying. 1 minute.
Read prayer. Why? Prayer needs no argument.
That we should be treated at par with those who have been given service, financial benefits after 8 years of their service. And we have been given financial benefits after 17 years. That is the grievance. And this has been adjudicated by this Hon'Ble Court, by the division bench, where it has been adjudicated that no discrimination can be done between this.
Can't you frame your prayer this way? I'm just telling you after reading many books on pleadings, I'm telling this. See that how you calling upon the parties to show cause as to why categorization under Rule 4 shall not be declared by straight way. Declare categorization null.
This is the way we are writing here.
It should be changed to accord with the patterns. Brother, you take notice.
Presentation is pending, madam. Presentation is pending.
How long it has been pending?
Yes, madam. Let it be considered then.
There could be one false round of litigation only. My lord,
you have made a representation.
Lord, that's what I am submitting. This is not the only one. There have been series of applications filed. Your lordship will deal with it. In few of them, we did go with this direction that the representation is to be considered. They have already started rejecting. So,
where are they?
If your lordship allows, then I'll produce those.
You take notice because the representation again they will be met with the same fate. Government considered rejected. And 48%
people have been given
of percentage of 48%. How they will produce the best teachers, best students, and without best students, how the state will flourish? The wealth is generated by wisdom, knowledge, virtue, not by substandard people. Is it not? Adam Smith writes Wealth of the Nation, famous book.
Yes.
He says, wealth of the nation is generated by knowledgeable people.
Elvin Toffler's power shift also does.
But if you appoint the bad teachers in the school, what should happen to our children?
The statutory remedy has to avail.
That's correct. But larger issue.
The statutory remedy, my lord. Let them, let them reject. He will come again.
No, that we will not. He cannot. Already you have rejected many such representations. Why he should be made to come again? Show me one case where you have positively considered the representation. So that confidence level has to be boosted by the government. Because our Vedas said, Vedic literature said, Rajaha Pratyaksha Devataha. Like in England, king can do no wrong. Ours is still higher. He is Pratyaksha Devata. That he would look after all the subjects as if God would look after us. Is it happening?
No.
Therefore, no. Your contention cannot issue emergent notice. First of matter requires the deeper examination. First of call this matter in the second week of September 2025.
Item 38.
May I please, Your Lordship? The matter relates to issuance of legal hair certificate.
What certificate?
Legal hair certificate. Your Lordship.
Legal hair certificate.
The petition is.
We considered similar matter. We posted it to some date, I do not know. We'll issue notice. You find out that decision also, those cases also. We are pulling up all these matters.
Here the issue is different, Your Lordship.
Different.
My Lordship. The present petition is the unfortunate mother, Your Lordship, who was lost his son, daughter-in-law and daughter in an accident within a month, Your Lordship. 3 child lost, Your Lordship. That the present petitioner asks for the son has 2 minor child, one is of age 4 and one is age 11.
That is grandchildren of
the petitioner, Lordship. So for the financial benefits of the pensionary, for the purpose, she requires legal hair certificate of the children, Lordship. Accordingly, she asks for legal hair certificate.
You want to know only?
Yes, that yes, Lordship. My prayer is for reconsideration of the application. That can be disposed of, Lordship. They have issued the certificate, excluding the present petitioner and her husband, the grandfather and grandmother. Only children have been included in the certificate, and the certificate, Lordship, how the authority harassing. The first one application submitted, and thereafter, during pending of that application, the authority suggested to file another application. Accordingly, I have filed another application for same purpose, and they have issued a Lordship. Kindly have a glance at Annex 2, page 25. They have issued 1 day 2 certificate, Lordship, and where the age of the child, Lordship, in page 25 in the first application, Archida Das, 12 years. Whereas by the application stated in the submitted, Lordship, that is age 11, and in the son, Lordship, that is 5. That is the age of the child is 3, Lordship, in the application. And the page 26, Lordship, in the another application, the certificate issued by the same authority. Here the daughter's age is 12 and the son age is 3, Lordship. The both I can't use either of the certificate. In both certificate, the wrong age is mentioned.
Deliberately,
Lordship. Deliberately, they are harassing, Lordship.
Why, brother?
Might be a mistake, my
mistake. You should not rectify. At least cancelling both the certificates and issuing one proper. She has lost children. Should he not have heart whether that officer has heart in the right place?
Well, this is the grandmother, not her.
That's all right. Yes. You want to trouble her for obviously for some reason. Does he need money? No, we'll send him money.
That is the factorship. Specifically about that in the pre application.
She has lost children, and having lost children, she seeks some certificate. And see the kind of certificates. He cannot make use of both the certificates. This is for obvious reason. No, he should be taught some lesson. I will not allow this matter today. Issue notice. Perhaps I will ask him to come here. Issue notice. Learned PG is requested to accept notice for the respondents. Which respondent?
The OP4 rulership, the issuing authority, Tahsildar, Gondia.
First off, learned counsel for the petitioner draws attention of the court to certificates at annexures.
Answer 2 series rulership, page 22.
Annexures 2 series issued by the same authority mentioning different years as age of 2 children. First off, he submits that in view of this mistake, which is not innocently committed, the concerned officer should be called to the court and made to pay heavy damages. First off, there is some ring of truth prima facie in this submission. First off, the fourth respondent is directed to be personally present before the court at 10:30 a.m. on 9th of August. On 10th of August, September, this is August, from today it's changed, na? August. Yeah, on 11th of August 2025. First off, next paragraph. However, his presence shall not be required if he grants redressal to the grievance of the petitioner in the meanwhile, and sends a copy of the same to this court through the learned DAC. He will do that. Otherwise, he ought to keep him present here.
Well,
so
you'll
1,000 rupees.
you'll rectify
in the service register.
Item 39.
Next rulership. Here the applicant is the paternal uncle rulership. Here the issue rulership, so for issuance of guardianship certificate for these 2 children rulership.
The same children.
Same children rulership.
All this.
Here the
notice, learned days is requested to accept notice for the.
Here the issuing authority is OP2 rulership, collector.
OP number 2.
But here the issue rulership, they have rejected the application without giving any opportunity of hearing to the party rulership.
Let us see.
Minors.
Call this matter on 10/8. 10, along with the serial number, which is that other matter.
11 rulership, fixed to 11.
11. Okay.
Here the collector is the.
All right, collector need not come. Let us see. First, we will see what we should do.
It can be disposed of. They have rejected the application on the plea that we have not supplied the required documents, which is not
now
actual.
There is an order. To set aside order, they should be heard in the matter. Otherwise, my judgment will be stayed in minutes. Because you are not, the judge has not given hearing. That will be first job.
Item 40.
It's got the appointment under the.
Thank you for
under the Rehabilitation Assistance Scheme on 2/5/2018 on contractual basis. After that, the judgment came before this one.
As a regular employee.
Regularization of the employees from the date of appointment. That is only my prayer, yes.
The similar matters we have posted to which date? Issue emergent notice. Learned ASC accepts notice for respondents. Call in the second week of September. Yes.
Item 41.
May I please, Your Lordship?
Yes, sir.
But here the petitioner although challenges the order of transfer, my lord, but here this is an order of transfer on rationalization, my lord. So rationalization of elementary school teachers, and this rationalization policy has the statutory support of the section 25 of the Right of Children to Free and Compulsory Education Act 2009. Your Lordship, I am having the policy of the state government 2025, my lord.
Okay.
But under the policy, my lords, two categories of teachers can be transferred, inter-district and intra-district. My case is intra-district, my lord. Your Lordship, may kindly come to case 5, my lord.
Of the policy?
My lord, of the policy, my lord. Clause 3. Clause 3, my lord, that is intra-district transfer, my lord. And thereafter, my lord, Your Lordship may
within the district.
Within the district, my lord. And next, Your Lordship may come to page 7 that decides the principle of inter-district transfer and rationalization. Principles 1. Teachers will be transferred from schools with surplus teacher to schools with teacher deficit. The requirement of teachers can be assessed keeping in view the PTR norms in Right of Children of Free and Compulsory Education Act 2009 and Odisha Right of Children to Free and Compulsory Education Rules 2010, my lord. Here there was no surplus teacher. As per the YASD, my lord, prescribed in the, Your Lordship may kindly come to the box under primary schools. From 1 to 31 enrollment,
two teachers.
We had 2 teachers being posted in the present school, my lord. And thereafter, Your Lordship may kindly come to next principle, Roman 6, my lord. Teachers who have completed 6 years of continuous service in one school would be eligible for transfer to another school. Here, my lord, I have completed only 3 years service from 2022, my lord. I have managed the order of posting, my lord. So, as per this stipulation, I am ineligible for being transferred, my lord.
Ineligible or entitled not to be transferred?
Not to be transferred, my lord. Your Lordship, then Your Lordship may kindly come to next page. Clause Roman 11.
When the transfer is effective?
My lord, 27, my lord, Your Lordship. 28/7/25, my lord. And this transfer has been done on the basis of rationalization, and another teacher has been posted against me, which is not permissible under this policy. Your Lordship may kindly come to that page. Since it's a policy of rationalization, they have to maintain.
What do you say, brother? You take notice.
Yes, my lord.
Issue emergent notice, interim order, staying the transfer order so far as the petitioner is concerned.
Under Annexure 6, my lord.
At Annexure 6 till next date of year. First, this interim protection is granted after perusing the policy transfer guidelines, which are said to have statutory backing. We'll keep this with us.
My lord, so I have this copy for this honorable court, my lord.
Item 42.
Hey, please do it.
Yes, sir.
Here also, matter relates to transfer of a teacher.
Intra-district or inter-district?
This is under Shiksha Vikas Samiti, my lord. Different district.
Within the district or outside?
Different district, inter-district.
Inter-district.
My lord. Without any reason, no reason mentioned, nothing.
No, why reason should be mentioned in the transfer order?
Nothing, only he has been transferred to one place to another place.
So how many years you have been in the same school?
16. On 2016, I am continuing in Sindra and a physical handicap teacher having 60% disability. Yes, legs. I have given the certificate.
Whether disabled persons, PWDs are entitled to some protection from transfer?
Yes, inter area he is unable to attend each day. That's why.
You are not properly answering the question. You are half-hearted.
My lord?
You are half-hearted in your submission.
The inter area, he has been transferred from.
We have understood. You have said it twice.
Yes, my lord.
I am asking you. whether the persons with physical disabilities,
Yes.
are they exempted from transfers?
Not at all, my lord.
Not like that.
No. But in the present case, his leg has been broken. He is unable to ride also a motorcycle.
When it was broken?
3-4 years.
When you were ever met?
I have given that certificate, disability certificate.
You have produced also?
Yes, ma'am. Annex 2.
Can he go in bus to other place?
Bus, yes, bus is also there, but 3 kilometers is inter area. It cannot.
There is no facility for transportation.
Transportation problem is there because inter area, that school is inter area.
Where is your certificate?
Annex 2, page 11.
Disability certificate.
Yes, some reasons also mentioned. So should have been mentioned. Nothing has been mentioned. Only it's a general only. A very low paid employees, 15 to 16,000, and they are unable to. That's
no quarters are given to these people there in the school.
Nothing. It is Saraswati under Shiksha Vikas Saraswati Shiksha Mandir. That nothing facility.
Issue emergent notice.
Saraswati Shiksha Mandir is private institution.
Yes, that it is maintainable.
Transfer against the private institution.
It is maintainable.
Which is that judgment?
Judgment of this honorable court. Chief Justice.
Copy of the petition also not solved.
You are not
website
state petition
State party
no. You give copy of the petition. We'll
state is not a party. Shiksha Vikas Samiti is a party.
They are not party.
They are not party. I have also.
Which paragraph says?
7, paragraph 7, my lord.
Paragraph 7.
Yes, my lord. 7 and 27 also. Imparting education or a public function.
Let us see. Issue emergent notice. First of all. Returnable within 3 weeks. First of all. Stay of impugned transfer order till next date of hearing. First of all. This interim protection is granted on the repeated assertion of counsel for the petitioner that he has 60% locomotor disability.
Yes.
In terms of disability certificate, copy whereof avails at Annex 2. First, okay. Let us see.
Yes. Publish.
Item 43. Item 43.
What is this matter, brother? For regularization?
Yes, my lord.
How many years he has put in?
More than 22 years, my lord.
Issue emergent notice. Is he removed or he continues?
No, they are continuing. They are continuing, my lord. Since long they are continuing. In the meantime, there are so many sanctions posts are there, my lord. Kindly peruse the annexure.
No, anyway, let notice go.
Kindly put one thing, my lord.
Why, even when I am agreeable with you, still you want to argue?
No, my lord. No, my lord.
This tells that.
In the meantime,
some satisfaction.
In the meantime,
he's sitting here.
My lord, in the meantime, no coercive action be taken, my lord, against the petitioners.
Coercive action? What coercive action they will take against you?
Whether they will any action to remove them or
not coercive action, not to remove.
No.
That will say that. Issue emergent notice. First off, prisoner shall not be disengaged without the leave of this court till next date of hearing. First off. Next paragraph. This interim protection has been granted on the assertion of counsel for the petitioner that his client has been working since more than
More than 22 years.
22 years. Uninterruptedly. And that there is apprehension of disengagement. First.
Item 44.
May I please, Your Lordship?
Yes.
That this matter was, I appeared on 2nd of March 2023. Then the file was missing, so I reported the matter before the registry. And Your Lordship, kindly say, report has come of the flag
saying that
the file is reconstituted and the initial order by Lord, the stay was granted by Your Lordship 11th of December 2018.
There was stay.
That may be continued.
Why continue? You will argue the matter on merits.
Today this matter has come. Your Lordship, can you see the note order sheet that past and the proceeding is also contemplated and has been delisted.
So that's all right. We have reconstituted the lost documents. They are your documents.
You'll also call this on next week or in day, I'll take instructions.
All this matter in the second week of September. Till then, interim order
passed on 11th of December 2018.
It shall continue.
Obliged.
Item 45.
Counter has also not come. The state in the meantime to be directed to.
In the meanwhile, counter may be filed.
That is an option.
Item 45.
Filing which the petition amendments may be taken with the prima facie credulence.
Gratefulness.
Item 45.
My Lord, in this case at the outset, I have a submission.
Yes.
The first one, there are two cases arising out of one order. Last order, my direction was
924 is one.
924, next one is 862 of 18. The first case, my Lord, the last order was, my landlord was to serve the copies. I am supposed to appear because I was a party in the tribunal. It's a one common order. I am appearing the second case for the respondent 4. The first one I was not noticed, so therefore I have the instruction to appear. So my landlord was directed to serve the copies.
In the first one also?
Yes, my Lord, because this is one order.
No, it may be one order relating to 1,000.
No, it is one case, one order, everything. State has filed one, state has filed the appeal, another is my landlord.
Say against the same person?
Same person, same order. So that is why, but no copy I have no copy.
The first case filed by the state, where I am a party as point number 1, my learned senior's client has not been made a party, Your Lordship.
I have no copy.
Has not been issued.
I am sure copy, my Lord. Let a copy be served, so I
not made a party, but the fact remains, Your Lordship, in the first case, it was disposed of. So kindly say that I filed an IA for recall of that order, Your Lordship. I filed an IA for recall of that order, Your Lordship.
For recall of that order?
Yes, Your Lordship.
The order is dated
16/10/2019. 16/10/2019, Your Lordship. Order number 3.
Other judge of the court?
Yes, Your Lordship. On the basis of a covered order, all the FAOs were serially disposed of on the basis of Anupama Thirampati.
It is not covered?
No, Your Lordship. For that reason, I filed an IA for recall of that order, Your Lordship. On the basis of that order, the FAO appeal filed by the state was allowed.
Against the said order, which has been acted upon by the learned single judge?
Yes, it was a tribunal under 24B. The appeal was pending before the learned state education tribunal, Your Lordship. Against that order, the state has come, even I have come, Your Lordship.
Both you have come. But in state's appeal, his client is not a party.
No, Your Lordship.
But who is party in that?
I am the, Your Lordship. I am the agreed person who have lost before the tribunal.
Both are party in the court below, my Lord.
Both were parties before the court.
But appeal filed by the state, my Lord, his client has not been made a party.
You have said that?
Yes, Your Lordship.
So he is being not made a party. Why you are saying that? How you are going to be advantaged by that?
Because my Lord is stating that he has not been served with the notice and the copy. There is not a party there at all. So notice is not issued, Your Lordship. That was I was saying.
The last order, my Lord, because I have not seen the.
So why, if you are not a party to that proceeding,
that
should be given?
The Hon'Ble Court has directed, because both the cases were there. Kindly see the last order. A direction was given that yes, copy be served on me so that I can.
In your case, it is.
No, I have not filed any case. All the cases I would have been an opposite party.
Law is A person who is not a party to the proceeding.
Not important.
No right to seek.
Yes, I have nothing to say. If they will not be party,
Huh?
if they will not be party, they have to face their peril.
Where's the argument?
So as my case is concerned, Your Lordship, the state appeal has been disposed of as allowed. So I will yes, Your Lordship.
State appeal is allowed now.
Yes, Your Lordship.
As a consequence,
my lords.
as a consequence of that, what should happen? That recall you are seeking of.
Yes, Your Lordship.
Allowed on the ground that on the following state of Odisha versus Anup Kumar Senapati.
My lords.
We'll come after. After eating lunch, we'll come back.
As a Lordship.
Item 45.
Before my learned senior starts, I need to appraise this court, Your Lordship.
Make use
I'm sorry. Before my learned senior starts, I have to appraise this court, Your Lordship. Again, I have again verified the record from that table
of the state.
Yes. Now I've seen that after the defect was pointed out by the staff for this honorable court, he has been made a party, Your Lordship.
Then he treated.
Yes, Your Lordship. I'm sorry.
Writing asking for that.
My lords.
Let him, sir. What I suggest again, my lord. Let the last order was to serve the copies. Let me top the copies. I am filing the power. That must be. Let it be urgent to some.
To file share a copy of the paper.
Yes. I will file the serve the appeal memo, my lord. IA copy, my lord. Not to have the IA copy. Both IA copy.
Learned.
I file the power. Yes.
Learned counsel Mr. Das of the
Respond 3, 4.
Three. Yes. P3. It is something. And has my power in that regard. First off, in the call this matter after 2 weeks. After 2 weeks, and in the meanwhile, the learned ASC shall share his papers with Mr. Das.
And also to me, Your Lordship.
And if the counsel representing respondent number 4. One.
I beg apology, Your Lordship. It should not have been done.
No.
He has not seen it. That is the problem. I was
Sometimes mistake.
And yes.
Item 40.
We also commit mistake. Yes. That is the reason why we.
That's how we improve upon Your Lordship.
Back to your please, Honor. I have preferred this writ petition against the impugned order passed in a civil division by the single bench of the Honorable Court, which has interfered and modified the first appellate court's order, while it was rejected by the regular second appeal and SLP of the apex court, Your Honor. In spite of these facts being rejected by the regular appeal and SLP, the learned single judge bench in a revision petition modified the first appeal. Against that order, I filed the writ petition, and this writ petition being against the single judge bench, Your Honor, I have filed the petition IA to assign the case to a DB with permission to change the nomenclature to WA.
You want to challenge order of the learned single judge?
Yes, sir.
That order was passed under 115.
Yes, Your Honor.
Of CPC.
Yes, Your Honor.
It's a revisional order.
It's a revisional order, Your Honor. By revision order, the judgment of the single first appeal was interfered and modified.
No, that's all right. Where is the intra-court appeal in respect of orders passed by the single judge under 115? It's their final orders. The only way is to approach the Supreme Court.
Your Honor, WA can also be agitated.
No. Even intra-court appeal is not permissible because once 115 is exercised, there is no intra-court appeal. If 226 is exercised, there is intra-court appeal. If 227 is exercised, no intra-court appeal. So there are few judgments which equate 115 of CPC to 227, supervisory jurisdiction. They are final orders. I'll give you some time. Just look into if there is any contra view available from the judgment, then we can consider your matter.
Your Honor.
Call this matter second week of September at the request of learned counsel appealing for the petition.
47.
In this case, my lord, I am in virtual mode, my lord. Your lordship has earlier appeared and your lordship has asked for the documents. The state and state has taken time to get the 7725 your lordship has passed the order. Calling for the document of RMC number.
77.
Madam.
Other judge passed the order.
Yes, madam.
Reads the record of RMC number so and so. My lord. Do we have that? The instruction, my lordship. More time to I'll produce the record. That ASC, after being confronted with the coordinate bench order dated 7/7/2025, seeks some time to comply with the same. First, call this matter in second week of September 2025, interim order to continue. Is it?
48.
I'm appearing for respondent number 1 to 3, my lord. In this case, I have today itself I have prepared the counter affidavit and sent it for vetting, my lord. I get only 2 days time, my lord. On by Monday it will be.
This is of 2021.
My lord.
After 4 years, you want to file the objections. What do you say?
Let me permit it to file a counter.
There is no adherence to limitation period for filing objections. Counter under your rules. Whenever you want to file, you will file. On this matter, in the first week of September 2025, at the request of learned counsel appearing for the answering opposite party respondents. First off, decision as to whether at this stage the counter can be filed will be taken in due course. We are not granted leave to file.
Item 49.
Yeah.
39 matter, we have also not filed counter matter.
Counter 22 matter. Same order. Other than that, you file counter, but we will consider whether it should be accepted on record or not.
It is short date.
What's the urgency? Urgency. Last week of August. This one.
Item 51, 50.
The sole question for consideration, Your Lordship, is whether M.Ed qualification, post-graduation qualification of M.Ed is equivalent to MA or not. The same has already been adjudicated by the Honorable Supreme Court. Your Lordship, may kindly see order dated.
But in this case, my lord,
Order dated, Your Lordship.
The Orissa Staff Selection Commission. And I'm standing counsel for the Staff Selection Commission. Here, my lord, on the basis of the requisition we received from the department, we used to conduct the examination. We do not have any competency to say that whether a particular qualification is equivalent or not. It is for the state to take a decision that whether a particular qualification is.
What do you say?
They have not filed any counter.
They are only conducting a body.
We are only conducting the examination on the basis of the requisition what we have received.
You have not filed counter.
But why 2025 years are over?
This is 23. 23 matter.
2023.
The one which filed in 2023.
Your Lordship, may kindly see order dated 14/7/23.
Salad, he wants to make the elections. You share the judgment of Apex Court.
Already given.
Civil appeal number 2850. All right. Finally, with the request of we call this matter on first week of September, second week of September 2025.
Item 51.
My opinions. This is the second journey of the petitioners before this Honorable Court for construction of an Anganwadi working center in a village. The Child Development Program Officer has written to the Tahsil for settlement of the land over 577 and 578. As the matter was after the report from the RI, after it was delayed, the petitioners have approached the collector, but the collector did not take any steps, for which the petitioners have filed a writ petition before this Honorable Court. And the division bench of this Honorable Court on 5/4/2019 has passed an order directing the collector to consider the representation in accordance with law within a period of 3 months from the date of production of certified copy. Immediately, the petitioners have produced a certified copy before the collector Jagatsinghpur, and the collector has not taken any steps. In the meanwhile, the collector has been transferred, and thereafter there are resurgence of COVID, my lord, for which the petitioners could not move to the collector nor even come to the court. Thereafter, the petitioners have filed this writ petition before this Honorable Court, the present writ petition. While the matter was pending before this Honorable Court, the BDO has constructed the Anganwadi Working Center in another plot on 20/11/23, and immediately on the next day filed a counter affidavit in this before this Honorable Court, and to which the petitioners have also replied. The same land which is still pending, plot number 577 and 578, but the Anganwadi Working Center has been constructed by the BDO in a different place, and also in a village.
Different place means different village.
No.
Same village.
Same village. In a same village, 2 to 3 Anganwadi centers can be constructed also, my lord. Well, the population exceeds more than 1/3. Even in one village, there are 4 Anganwadi centers.
No, that is not the question. There may be 10 wine shops. Question is, what is your right?
We want that in our 577, 578, Anganwadi worker center should be established.
What is your right to ask that?
That land is a Gochar land, objectionable land, my lord. Which my lord?
That plot is objectionable.
Objectionable, Gochar land, my lord.
Where is your prayer? Go to prayer column. They have established. You can't say government should build the Anganwadi, a particular place only.
Annexure 1, your lordship may see, the Child Development Program Officer has already applied to the Tahsildar.
Anyway, now they have already established it.
Established, I mean, another place.
In which, what is your right to insist that government should establish Anganwadi only at this place? It is not Ayodhya temple.
That we can say.
That's what, nothing. Right on. Petitioner is knocking at the doors of the court. Petitioners are knocking at the doors of the court with the following prayer. First one. Next paragraph. When confronted with the question from the court as to what right the petitioners have got to insist upon the construction of Anganwadi Working Center at plot number 577 and 578 of Karamanga, is answerless. First up. Next paragraph. One sentence. It is a settled principle of constitutional jurisdiction that no right, no right. First stop. Next paragraph. Learned ASC appearing for the answering respondents submits that even otherwise the petition has become infectious in as much as Anganwadi Center has been established in plot number, my lord,
94/1406.
1406.
Right. Just give the number.
My counter value page 2. My
294/1406.
Yes.
6.
First up. the essential grievance should relate to establishment of Anganwadi center and not the spot at which it should be. First, next paragraph. In the above circumstances, writ petition being thoroughly misconstrued is liable to be rejected, and accordingly it is, courts having been reluctantly made is.
Item 52.
Petition challenging the Annex 10 of the order rejected by Director Technical Education is the fact that petition, after facing rigorous recruitment, successful as an assistant training officer, and an appointment letter has been issued to petitioner to joining as a ITI Kotokada. But unfortunately, due to serious illness, he cannot joining in during time only 2 months or 29 days delay, and after recovering of health on 17/10/2020 to file an application before authority to consider sympathetically, and a medical certificate also supported in the.
What was the disease?
Medical certificate.
Bimar kya tha? 3 words I have learned now.
Medical certificate Annex 5.
What is that disease?
Madam, this is FUO, fever of unknown origin. FUO
means what?
Fever of unknown origin. Medical certificate is Annex 5.
And is that
5, page 15.
What with 5? Medical certificate of sickness. Who is the doctor? So what is the disease? Is not mentioned at all. Medical certificate should mention the disease. Unless it is protected under privacy clause. That is not your case because you have made it part of the annexure.
Suffering from APO, doctor issue a certificate and taking a bed rest from 24/7/22 to 16/10/22.
What is meant by AUO? AUO.
FUO. Fever of unknown origin.
Fever of unknown origin.
Unknown origin.
The certificate also appears to be of unknown origin. So that certificate will not satisfy the requirement. When you were supposed to join? What is the post?
Annex ITI Assistant Training Officer.
Assistant Training Officer.
ITI. Kotagada.
ATO.
Annex 4 is the appointment letter.
Within what period you were supposed to report for duty?
Within 15 days, my lord.
Within 15 days?
My lord.
Is it mandatory?
My lord.
Whether that post is still vacant?
That
verify if that post is still vacant. Now, who will say no to the appointment nowadays? Unless there is a genuine ground. Everybody will go for appointment, na?
Appointment order issued on 18th July 2022.
18th July
2022, my lord. And he requested to join, my lord, on 17th October 2022.
17 October
2022.
That's all right. He is saying that he was not well. Certain whether that post is still vacant. If it is vacant, because he has already written examination, his interview has been conducted, and he has emerged victorious. Who will say? Who will stay away from the appointment nowadays? You are seeing so many cases for giving appointment, regularization, reinstatement. Is it? There must be some reason. It appears to be some genuine reason. Look into that. Learned ASC is directed to ascertain whether the post to which the petitioner was sought to be appointed still continues to be vacant, or some other vacancy elsewhere avails. First off, call this matter on 21/8. You should not deprive candidates once having a no. There is some lapses, sometimes some diseases, they come in the way. The bacteria and virus are very unkind to man and very stronger than man.
He has to communicate the same regime to the authority. He has to communicate the same regime to the authority in appropriate time.
That's right. But we can ascertain.
But others are waiting.
Just see whether that vacancy is there. If there is vacancy,
yes, ma'am.
Perhaps we have to consider this case.
Item 53.
Which rule prescribes within what period man should report for duty?
Yes.
That also.
My lord, within 6 months, Annex of 7 is the circular.
No, 6 months, 30 days, man.
No, 6 months. 6 months.
No, it cannot be 6 months. Almost in every state it is 30 days. Unless extension is granted on request.
He has not prayed for that.
My lord, Annex of 7 is 6 months is granted.
That is.
Annex of 7.
What is this matter? Yes, sir.
53.
53, my lord, will file counter.
You want to file counter?
My lord.
23 matter.
23 matter, my lord.
Call in the second week of September.
23.
Request of Learned Council.
Can you read the earlier matter? If possible.
22nd of August.
Yes.
Item 54.
With this reading complete, my lord. I pray, my lord, I will file some decision. Let's see, next week candidate. Reading complete, I have also filed the written notice of argument only.
Next week we will have difficulty. We will have it in the first week of September.
No, in this month, any day, 1 week after, let's see.
11th, we have already posted many matters. Otherwise, I would have had that. Try on 25.
Item 55.
Yes, sir.
Notice has already been issued to the opposite parties, and the matter is relating to setting a direction to the statutory authority for correction in the certificates regarding name change, my lord.
Name change?
Yes.
We have passed made one order. In which certificate?
In all academic certificates.
Academy means up to university?
No, up to the she has qualified up to +2.
+2?
Yes.
So PUC board. +2 board is there? University?
No, the council is there.
Is there board?
No, council.
Council. Okay. Anyway. Council. Who appears for the council? Name has to be changed. Wrong name is printed.
Yes, my lord. Because
or you want to have new name itself?
New name.
Board certificate.
Full new name.
My lord, what happens in this?
Rectification of names can be done. But having entire re-christening is permissible or not, I don't know. Many consequences may follow.
But title will be the same. My lord, title will be the same, but so far as the first name is concerned, that is to be changed.
What name it is? From which name to which name?
From Asanti to Aisani.
Asanti to Aishali.
Aisha. Asanti to Aisha.
Why any astrologer has advised you?
But name has already been effected in the Aadhaar card and PAN card, maybe.
That change is effected?
Yes.
What name as reflected in the Aadhaar card to be reflected in the school records?
Yes.
What do you say, brother? Any rules are there regulating? Other day, Tripathi said that there are some.
Board regulation is there, separate councils are appearing for the board and the council also.
Which council appears for the board?
One matter, your lordship, in my case, day before yesterday.
Correct. That was but before the SSC board. It was not before SSC board. It was 9th or something like that.
10th certificate. He is also seeking, I think,
No.
board certificate.
It is in respect of SLC board, PUC board also, council also.
Council also.
They have, you just look into. For SSC board, you appear.
Notice received on behalf of the opposite number 1, 2, 3 by the statement. On the last statement. 1, 2, 3.
But the ASC is learned. ASC is saying that he appears only for. There is a panel council for board.
Board of Secondary Education, my lord.
So board is
Council of Higher Secondary Education. Who appears for Council? Rao.
no,
Not
no, notice has been issued by the registered post with 30. Notice has gone to 4 and 5.
What do you say, brother?
4 and 5 is the council as well as the board, my lord. I am for 1, 2, and 3, my lord. The health secretary, director of higher education, and the.
Did you make the application?
Yes, my lord.
Where is that?
That application was not with me, my lord. But I have made application. I have also personally approached different authorities, my lord.
No, at least some application you should have made. No? What we will do is, we will dispose of the petition with liberty to make an application in the prescribed form. If that application is made, they have to take a decision within 3 weeks.
Yes, my lord, that will suffice.
Because you are seeking for mandamus. Unless there is demand and refusal, no matter.
Then I will make a fresh application, appropriate direction.
That's what. Petitioner seeks change of her name in the educational records, both at the level of SSC board and what is that council called as? Council of Higher Education, Higher Secondary Education, Odisha. First off, despite after service of notice, the OP numbers
4 and 5, my lord.
1, 2, 3, 4. 1, 2, 3, and 6. Correct.
My lord.
For whom you appear?
For 1, 2, 3, my lord.
1, 2, learned ASC appears for 1, 2, and 3. OP numbers 1, 2, and 3. First off, despite service, other respondents have chosen to remain unrepresented. Be that as it will. Next paragraph. Petitioner seeks change of her name, as already mentioned above, to accord with the names mentioned in his Aadhaar, in her Aadhaar card.
It's Aadhaar and PAN, both.
And Aadhaar and PAN card.
Yes.
First up. Learned ASC points out that possibly there are regulations which govern request for change of name of the students, since such a change will have many consequences. First up. He also points out that there is no representation made as yet on record, and in the absence of a representation, ordinarily a petition for writ of mandamus would not lie. First, this appears to be the broad proposition of law obtaining in the realm. First, next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to make appropriate applications to the concerned educational authorities, seeking change of her name in accordance with law within 3 weeks.
Yes.
First one. Should one be made, the jurisdictional authorities shall consider the same within an outer limit of 4 weeks and inform result of such consideration to the petitioner. First, next one. It is open to the jurisdictional authorities to solicit any information or document from the side of petitioner if necessary for due consideration of applications in contemplation. First, of course. Indicate yes, sir.
My lord, counter not received from the state, my lord. And opposite party, 5 and 6 also not served the copy of the counter.
So 5 and 6 file the counter, serve the copy. If he wants, then I can give.
No,
But here,
Your friend is saying if he wants, I will give you one more. But let him not complain that I have not given.
because that is not there. Because since I have solved, the noting is not there. But one thing I must say.
Solve the copy, man.
You have served the copy. You serve copy.
Yes. Just after 10 minutes, I can serve it. And one thing I request, because the interim order is operating against me, with regard to my country.
Then we will take up the main matter itself. We'll dispose of the main matter.
Yes, that's why I want. I am serving copy in course of the day.
State is not file the counter. Let the state to file the counter.
They may choose not to file the counter itself. They may find sufficient material for dismissal of the petition in your petition itself. Is he not entitled to find out? You don't want to file the objection?
Yes, sir.
You want to file?
Yes.
When will you file? When your officers will wake up and brief you?
Which time?
January island का पारावारी को माना
इस तो नहीं
16
Call this matter in first week of September 2025 for filing any counter if any, filing counter if any, failing which right to file one stands forfeited.
Draft not received.
Draft I received and you have kept it in your file.
since January.
Prepared, na? All right. You share copy of your.
Yes, sir.
Section 57.
I request my friend to supply the copy of the counter.
Counter affidavit.
Counter. They have filed it in February, madam.
Counter is not given to you.
No,
I will sort in copy.
Yes. Second week of September. Yes, at the request of the
Item 58.
May I please?
Yes, sir.
Yes, Your Lordship, in the main writ petition, the counter has not been filed. In the IA, may Your Lordship pray to kindly see the order dated 3/1/2025, Your Lordship. Sorry. 3/1/2025. As for this Honorable Court direction, Your Lordship got it. In IA number 15541 of 2025, this Honorable Court has been directed in the last paragraph 5, Your Lordship. Having heard learned counsel for the parties and considering the submission made this court while disposing the IA permits to the petitioner to join in terms of the office order dated 30/12/2024. The break period till the date
they permitted you
be regularized.
They permitted you to join.
Permitted, but they are not
treating that. They are not regularizing the service.
No, he's regularized, Your Lordship. They are not releasing my salary, Your Lordship.
Brother, why?
I got the instruction. In this case, they state that the petitioner did not join the government primary, rather to shelter of the Honorable High Court. The Honorable High Court kept the order number such and such dated in abeyance. That after the order passed.
That is Your Lordship stay order 22/10/2024, Your Lordship.
That is kept under subject.
In abeyance, Your Lordship.
22/10/24.
Yes, Your Lordship.
Thereafter, order passed by Honorable High Court, the petitioner proceeded to government UPS Shiraguda and performed duty only 2 days, my lord, on 28/10/2024. And
that we have crossed now. Come to the other order which your friend has read, na?
Yes, sir.
That argument is taken care of.
My lord.
Kindly come to page Then page number 60.
So now, now the authority, your lordship, only releasing except the in the month
Only
of
come to 3125 order. No, not the that's the order. No, you read another order. No, which order you read?
that is your lordship.
The order to regularize your service.
That is your lordship 3/1/2025, your lordship.
3125.
Yes, your lordship.
But this order was kept in abeyance.
In main petition, your lordship. In main writ petition, that has been kept in abeyance. In IA number 15541 of 2025, the order dated 3/1/2025. On that order, your lordship, they passed the for regularize the that period, your lordship.
Order is kept in abeyance means stayed.
Yes, your lord.
Why is that kept in abeyance?
Because if your lordship, this is a transfer. The petitioner is challenging the writ petition under the transfer, your lord.
Now that they have regularized that service.
They are regularized.
And they took you back.
Yes, your lordship. They are regularized, but
They are not paying the salary.
not paying the month of October, November, and January, February, your lordship.
You have taken the classes there.
Yes, your lordship.
No, my lord, she is absent, my lord. After puja vacation, she remained absent from the duty.
During
2010, she joined the duty and worked up till 29/10/2004.
But they are saying, your lordship, on that period, the puja holidays was going on, your lordship. So how can
How many days? Puja, well, 3 months?
No, 10 days, your lordship. 10 days.
10 days.
Thereafter, she was joined, your lordship.
Is it true?
My lord, she is absent, my lord.
Produce the attendance register. Produce the attendance register.
Shape of instruction, I will file it as a reply. Time may be given.
Learned ASC is directed to produce the attendance register of the petitioner, which would reflect her performance of appearance and performance of attendance and performance of duty during the relevant period. First off, if not produced on the next date of hearing, heavy adverse inference would be drawn against the official respondents. Call this matter in the second week of.
Oh, blood. Interim order to be continued.
Interim order to continue.
Gratefully, Lord.
59 till then.
May I please, Your Lordships?
Yes, sir.
Well, the sole issue is the suspension period. Despite being regularized, the financial benefit was denied.
On what ground?
But no ground. My lord, kindly see the approach this honorable court. This honorable court gave an opportunity, my lord, to the government to consider annexure 10, page 31. The 11% of the order, my lord, page 33.
10/4/2024 to 29/4.
Yes, 2005.
That is 19 days. 20 days.
No, 10/4/2003 to 29/4/2005.
That is
2 years, around 2 years.
2 years.
Yes.
They were kept under suspension for 2 years.
For 2 years. And no reason, my lord. If your lordship look at the suspension order.
Kindly look at me, then I will look up your suspension order. You were under suspension during what period?
During the period, my lord, 10/4/2003.
10/4/2003. 3.
My lord, to 29/4/2005.
Then suspension was revoked when?
On 29/4, my lord.
Where is that order?
Annexure 5, my lord, kindly see page 19.
Go to page 19. Afterwards, what happened? After suspension, what happened?
My lord, kindly see, that was in pursuance to instructions of the government. No proceeding, nothing else. Then, my lord, and revocation was page 21. In pursuance of government order dated 28/4/2005.
Why did you suspend and why did you reinstate?
No, there's no reason. Earlier, my lord, there was a vigilance case. It
has been paid, my lord.
When was it paid?
The total area amount is 42,10,300. It has already been paid to him as per following details. Considering his suspension period as leave due and admissible. Area pay 2003 to 2005, 45,340. Area salary wise out of pay fixation under ORS SP rules 2008 7,37,599. Area salary out of pay fixation under ORSP rule to 28.
Where are you reading?
My lord, this is the instruction. Parawise comment I have received.
What I should do with your parawise comments?
My lord, I'll file a counter. I'll file a counter.
I'll just clarify one thing, my lord.
Already paid.
For your lordship's convenience, my lord.
They are saying paid.
I'll file a counter.
That. How it was paid? Just which pay you have to pay it by check, na?
That is not reflected in.
Then he will say I have paid. He will say I have not paid. What the court should do?
No, what they have done, my lord. What they have done, my lord. In this case, my lord, what they have done, they have treated that period as leave due. That was my challenge, my lord, before this honorable court in Annex page 33, my lord.
It could not have been leave due at all.
Yes. How can leave, my lord? Your lordship knows the honor somebody applies. No leave can be forced.
You cannot force leave on him. You have suspended and you have revoked.
You have reinstated.
1 second, sir. You are online and you are making so much galata. You don't permit us to ask the question. Firstly, you are online. Half by distance. Then secondly, you are disturbing. Brother, why you suspended? Why you reinstated? And what was the action taken? Why public money should be given to him on our own? You recover that money from those who are responsible for the suspension. It's public money. You can't, you want somebody to be suspended, you will suspend. One fine day you will have good dream and you will revoke the suspension. What is happening here? 2 years. For 2 years salary, who will pay? You can't deny salary to him because you cannot force leave on as an employee. And you can't spend our money for making payment to him. You have not filed objection statement.
No.
We'll pass strictures both on you and on the officers also.
I'll counter, my lord. Time may be given.
What, brother? How long?
I'll counter.
Call this matter in the on 22nd of August. At the request of what is this happening? No action taken, nothing. You just simply suspend and simply reinstate.
Item 15.
May I please?
Yeah.
The petitioner applied for the post of education volunteer in the scheme of education guarantee scheme, madam. He was selected his position at serial number 2 in the merit list.
Are you ready in the matter?
No.
Well, in the second week of September, at the request of London DST, finally. Finally.
Item 61.
In the meantime, already I have served copy to the Council of the OSRTC.
Yes, sir.
Yes, my lord. This may come next week along with the present case.
Which is that other case?
Am I live giving the list?
For this matter, along with WP number. In the first week of September, we'll have that. The 2 weeks we are extremely busy. Many cases we have appointed. Or third week of August. Third week of August, all right? Third week of August.
Item 62.
May I please, Your Lords?
Yes.
I am appearing for the petitioner. I have received the counter affidavit. I pray 15 days time being granted to
may we concentrate
on the petitioner.
In this case, I am appearing on behalf of the staff selection commission. Only one. So, Your Lordship, my lord, while entertaining in this petition as well as issuing the notice on 18/6/2025, Your Lordship have been pleased to stay the further operation of the recruitment process
Whole recruitment process.
That is why, my lord, I am not objecting for today's adjournment for filing of the rejoinder. What I pray, my lord, if possible, my lord, then it can be taken up in the last week of August or third week of August, as your lordship please.
All right.
As your lordship.
Or in the last week of August.
Interim order may be conflicting.
Interim order is a stay of entire recruitment process.
Part.
My lord,
In part
my
only
lord,
two
there are,
subjects.
my lord, there are 8 categories of the post. Out of the 8 categories, 2 categories of the post. Now that has been stayed. In the common recruitment.
To get a stay.
In the common recruitment process. So that is when
Then we'll have this matter on 21st.
most of the time.
21st. You can't keep stay that way.
Okay, interim order may be
The
conflicting.
request of the counsel for the petitioner, interim order to continue only till then.
Obliged.
Item 53.
Earlier, a requisition was allowed and direction was given to give me appointment in the post of Shiksha Sahak. I belonging to vision impaired category. I belong to vision impaired. But it is a small mistake in document. They consider me as the hearing impaired. So this Hon'Ble Court.
Your impairment is?
Vision impaired.
Vision impaired.
Vision impaired.
Okay.
So, due to my lord, some kind of official mistake in submitting the candidature or for as far as their consideration is concerned, so they categorized me as the hearing impaired. So, Hon'Ble Court, my lord, after analysis of all the things, directed that it is a factual error. Accordingly, direction was given to the state project director to give me appointment under the hearing impaired category. So, in spite of the order, the plea taken in the counter and the impugned order which was quashed earlier, again in the present situation restored the same thing. You belong to hearing impaired and you do not belong to vision impaired, so your case is not considered. This is the thing. I belong to the vision impaired. So 2 posts.
Where is
Page 62. Page 62. Paragraph 5. After hearing Lord and counsel for the parties and on going through the materials on record, particularly the copy of the application submitted by the petitioner enclosed as Annexure 4 series. Annexure 4 is my disability certificate. Yes, ma'am.
This appears to be factual error.
Factual error.
Affected in the impugned order. In such view of the matter, no fruitful purpose will be served by keeping the petition pending. To consider the matter of fresh by taking note of the application along with disability. No, matter was not. There was a direction to reconsider.
Reconsider.
Whether you are hearing impairment, case of hearing impairment or visual.
Yes, ma'am. Correct. Again,
they were said
in the previous counter, they were saying that you belong to the hearing impaired. So again in the impugned order, it was interfered and
remitted the matter for fresh consideration.
Fresh consideration. Correct. So instead of considering my case afresh, categorizing me as belonging to vision impaired category, again restored the same thing that you belong to hearing impaired.
Where is the material to show that you have hearing impairment?
Yes, ma'am. I belong to page 28. Page 28. Disability certificate.
What to 28?
Page 28. Visual, visual acuity, VA.
28.
Page 28.
Visual disabled. I'm hearing. Where is that? All three are everything is there. Physically disabled, visual disabled, speech and hearing disabled.
No, my lord. Visual.
Percent inverse. Which is that? Where is the marking?
40%, my lord. Page 28.
40% all right. In what?
This is VA. In case of VA. VA. Visual acuity. Visual acuity. So I consult with the doctor. They saying that visual acuity means esotropia and agophoria. So it is a kind of, to some extent, the mild blindness, mild blindness, visual acuity.
The doctor's writing is very difficult to understand for the patients and judges also. What do you say, brother?
My Lord, on this occasion, the Honorable Court on admission of the case, my Lord, observed that once you are directed to consider the case FS, categorizing the petitioner as belonging to vision impaired category, so they repeated the same thing. So, my Lord, violating the order and observation of this Honorable Court, the order dated.
Where is the violation? It was like a reconsideration order. After reconsideration, they have categorized you into the same category.
Same category.
But you say that is wrong.
Yeah, it is wrong.
To substantiate that, where is the material? This is the, it does not make sense at all.
No, my Lord, I pray, page 54, in the earlier, there was a personal hearing by the state project director. Page 54, paragraph.
Now, what I suggest is, whether you are visually impaired or hearing impaired,
not visually impaired,
you undergo the examination at the hands of the medical board.
Yes, my Lord. Visually impaired. I will produce.
You undergo the examination at the hands of the medical board. Then, based upon that report, we will take next.
Yes, my Lord. Yes. Only set this thing.
The short question that arises for consideration in this matter relates to whether the petitioner is having visual impairment or hearing impairment. First off, this question arises because of unintelligibility of the disability certificate issued by the competent authority. First off, there was earlier round of litigation in WP number 27575 of 2020, correct?
Yes, my Lord.
2020.
31848. 31848 by 23.
31848 by 2023.
Page 62.
Disposed of by a coordinate bench of the court by order dated
13/9/2024.
13/9/2024. First off. Next paragraph. In the fitness of things and to lay the dispute at rest, the fresh certificate to be produced by the petitioner would come handy. First off. In view of that, petitioner is directed to undergo fresh medical examination at the hands of District Medical Board. District Medical Board. Which district?
By Baleshwar.
And produce the certificate of examination on the next date of the April. First, the District Medical Board shall examine the petitioner properly on a normative basis and furnish a certificate, appropriate certificate, depending upon the impairment. First, call this matter on in the second week of September 2020.
I'll produce a lordship's order before the District Medical Board.
Correct. The District Medical Board shall accomplish this task on the production of a copy of this order. Or we have a copy of the order. As one you have copy of the order. Yes.
Kindly have a glance to page 30. My Lord, 1-3, Annexure 2.
This handing over Gram Panchayat roads to RD department.
Yes, my Lord. Money has been sanctioned during when the road was controlled by the Gram Panchayat, my Lord. But no work has been done. So, Lord, you may see serial number 1, Ichhapur to Bakrabad, construction CC road from Bakrabad, Baurisai to Kerasai.
That's what
Last occasion they said that we will fight counter. But not necessarily, Lordship. Annexure 1 can be disposed of.
Annexure 1.
The repetition with regard to. And here.
Take out Annexure 1. Annexure 1. What is that Annexure 1?
The demands of the petitioner for construction of read. That is in Odia. English.
I'll try to understand.
Yes, Mr. The collector, district magistrate, Jagatsinghpur, regarding construction of CC road from SC hamlet between Bakrabad, Baurisai to Upper Kerasai, which is reflected in Annexure 1. That road has been handed over, money has been sanctioned, the work has not been done below. Against that road, number of times false bills has been.
Your President Dalit
Masan.
Vikas Parishad. This that annexure is at 4/11/2024 annexure.
Yes, Mr.
That if that is considered over.
Well, funds already road has been transferred.
No, you have said it about 3 times now. Work is not done, despite allocation of funds. That is your case.
My lord.
If this representation is considered,
not considered. That's why
if the direction is given to consider,
yes,
that will be sufficient for you.
Most likely.
Right. Petitioner, he is the president of
President Dalit Vikas Parishad Jagatsinghpur.
Petitioner claiming to be the president of a union of downtrodden communities is knocking at the doors of writ court, grieving against non-laying of roads in the village in question, in 3 villages.
LC hamlet between Bakrabad, Baurisai to Upper Kerabasti.
Despite allocation of funds. First. Next paragraph. Basanto. Learned counsel appearing for the petitioner in support of his contention that funds have been allocated draws attention of the court to the letter dated 29/11/2024 issued by the block development officer Balikuda at Annexure A2 and submits that despite this, the work is not undertaken and that there is absolutely no reason for not taking up the said work. First, therefore, he submits, intervention of this court is eminently warranted. First, next paragraph. Despite service of notice, no objections are filed from the side of respondents. First, however, this court in matters like this cannot eternally wait for filing of the objections, asking the litigants to wait in the queue with no justification whatsoever. First, when a worthy cause is brought before the court, earliest redressal has to be granted to the litigant, whether the authorities and the government would file objections or not. First, next paragraph. In the above circumstances, this petition is allowed. 7. The writ of mandamus issues to which respondent?
Respondent, collector.
Which respondent is?
Respondent number 3 below.
To respondent number
3.
We'll say all the respondents.
Below.
So the respondent responded. So consider the subject representation dated, which is that? 4/11/2024, a copy whereof avails at Annexure 1 below. Annexure 1. Annexure 1. Within a period of 4 weeks, in accordance with law. First up, report of compliance should be filed with the Registrar General of this court within 1 week next following. Failing which, it is open to the petitioner to make an appropriate application to this court to take punitive action against the erring officials. All conditions kept for summary of now no costs. Next time, if they don't do, no application. I will impose 50,000 rupees cost on all of them. Yeah.
Since matter is already fixed to 15/9, immediately I get the memo, directly comes on the debt list, my lord. On the debt list.
Item 67.
67, my lords, I am appearing on behalf of opposite party number 3 and 4, Lordship, today.
Yes.
Lordship, can kindly get 2 weeks time to file counter.
2 weeks, my lord, this is a matter where a coordinate bench of this honorable court was pleased to issue notice on special messenger. Being the fact that, my lord, I am, my lord, challenging the appointment of opinion number 4. So she has got appointed, my lord, as a guest lecturer. The tenure is only 10 months, madam. So my humble submission is, my lord, the senior is appearing today. The short date will be fixed for him.
Yeah, 18th, can you have this?
Yes. Yes, lords. Yes.
8th, my lord, it is.
Yes. 13th.
My loss. And my lord, only my prayer is, in my entire allegation is, in 5 I secured 36 marks. The person got 31 has got appointed. So if my lord and senior will be able to got the records, my lord, now affidavit to that effect, my lord, that will be solved in next chapter.
31. Both this date is fixed.
Only one, sir.
At the option of both the sides. Finally.
Only one, sir.
Yeah.
And it will be on 14th, Lordship.
14th.
Grateful, Lordship.
68. Item 68.
Yes.
Lordship, I am appearing for the appellant. Lordship, some documents were sent for inquiry and to submit a report. And Lordship, on last order, that is 18/7/25, this honorable court has directed to submit the report, and somehow we have not received the report, Your Lordship.
Report to be submitted by whom?
It was referred to the so far the signature and some disputed documents, because of his authenticity of the sign regarding an appointment. This has been sent to the CBI CID crime branch. So one of the report, this has come, and I have sought the copy one set, and the report one set also available. Another set is available with me, though it has not been Xerox extra copy. I can serve it also due to, because in the meantime, the last
says.
But one report says it's okay. So far, this manipulation of documents, so far the signature part is concerned of the 2 applicants. One is of the applicant, another is of the respondent number 4. So another report is come. This has I have opened just, so I have got the document. I can also hand over it for the kind perusal.
Just look into the document, all concerned. Look into the.
And one of the set, 2 sets are there. One set I have got I can also.
No, you give.
Hand it over so far the Xerox copies.
Other copies also. Do you have Xerox here? Huh? Give it. We'll Xerox it and do it something. Xerox it and give them. Take Xerox copy, sir. You can take Xerox copy so that it will help you.
Well, so far as the inquiry report pursuant to the order dated 18/12/2024 is concerned, that I have received.
that you have received.
Yes.
Which one you have not received now?
6/12/2024. 6/12/2024.
Mr. Monty, 6/12/2024 is what you have.
That I have, though I have received, but I could not able to.
You
Original
just
copy hai.
distribute to everybody.
Another bulk of document that I have made the xerox for the court as well as for the office.
You receive the report, go through this.
Yes.
I will post this matter on 13/8.
Because the interim order is operating against us.
But now the opposite party, I have succeeded in the lower court below, and now as per the misinterpretation of lordship's order, I am not getting salary though I have continued since 2019, and he is a terminated employee. And at his instance, I am not getting salary. I am discharged.
But his service.
Lordship visualized since 2019, I am not getting salary. So some interest is there.
No, his service has been terminated since 2010. He is out of service.
No, that is.
He approves the State Education Tribunal. In the tribunal, he lost. And because of the interim order, the other person whose appointment has been approved, he is not getting his salary.
On 13th, they can be disposed of the matter.
I am going to retirement.
On 13th,
On 11th, we can have the matter on 11th.
Here, my lord, in respect of the appointment, 2 dates are, that is the crux of the point. One is 1991.
It has been exactly that.
The authenticity of the documents.
Yes.
And the last is
Afternoon, it sounds very wonderful chorus to hear chorus argument.
this is a matter of how
11th will have.
lady teacher.
More particularly in Friday also. More particularly in Friday.
Yes, 11th we can have this matter. All this matter on.
that's all.
I have received the copies now.
No, it will take some time. It's a bunch of documents.
You just
Vice Mayor, you'll also take out the matter on 11th. This is my.
Yes, go through the report, it can be disposed of.
You will take up on
On
11th.
that day,
After submission of that report, everything will be clear.
Everything is-
Exactly. Remove the clouds, man.
item
Interim order to continue.
Interim order to continue, still there. Yeah.
Item 69.
Passover, my lord.
Passover. Brother, it is 3:15, Friday. You are asking for Passover. We'll have it next week.
Next week, man.
Next week, difficulty. Week after next we'll have. Call week after. That's the request. Well, lawyers are not going out on the weekend. They are supposed to.
Item
Weekend, you are supposed to go with the family. Otherwise, how your families will be filing a complaint against you? Yes. You become more energized when you come to court on Monday.
Item 70.
70.
Call this matter. I'm not ready. My lordship, call this matter.
In the second week of September?
My lord.
At the request.
71.
Well, item 71.
Yeah.
This is covered by the coordinate bench of this honorable court. That 100 Girls High School case, I am supplying a copy.
100 Girls High School case.
100 Girls High School
We
case.
did in law school 6 carpenters case. In law thought.
Yes, yes.
Winfield and Jolovich.
My lord. My lord, here what has happened? Well, so far as 100 girls' high schools are concerned, those schools became eligible to receive grantee aid from the state government with effect from 1/6/1994 as per the grantee aid order of 1994. That is the admitted fact. But those schools were not notified to receive grantee aid from the state government with effect from 1/6/1994 as per the grantee aid order of 1994. Those are left out schools. Subsequently, another grantee aid order came into force, that is grantee aid order of 2004. And for these girls' high schools, they were allowed 100% block grant with effect from 22/9/2007 with annual increments and other benefits from 1/6/1994. Some similarly situated schools out of that 100 girls' high schools approached the tribunal, this honorable court. They succeeded in the tribunal, they succeeded in this honorable court, and the matter also went to the honorable apex court. They also succeeded there.
Grantee rate was made available to those schools with effect from 1/6/1994 as per the grantee rate order of 1994 because they are covered by para 7 of the grantee rate order of 1994. Some left out schools also approached the tribunal subsequently. Some cases were rejected, some cases were allowed. Again, that matter came up before this Honorable Court in different FOs, and this Honorable Court, by taking note of all the judgments, including Anup Sanapati and others, has held, your Lordship may kindly see.
This is a single judge.
Single judge judgment, identical case.
Not put in appeal?
My Lord, not put in appeal.
Mr. Mohanty?
My Lord, that I have to check it.
We'll have it
Monday.
Monday.
Copy visa.
Yes, Monday.
I can.
I have already said.
Call this matter on Monday. Since it is submitted by learned counsel for the petitioner, that matter is covered by coordinated decision.
And hundreds of cases have been disposed of in the same light.
Yes.
My Lord.
Anyway, then first
Next.
The 22.
The 72. Yes, so that is also my case. My Lord, here, the My Lord, here the petitioner was appointed against the post of 4th peon on 3/11/1990. Well, as per the yardstick dated 8/7/81.
Mr. Mohanty, ready?
No, my Lord, 70 to 73, I need some time. Both belongs to my learned senior.
And it's short matters.
2019 matters.
Yes, one. I am conscious one.
Then let it come on Monday.
No, we have difficulty. We have seen so many matters. We'll have it on 13th of August. 13th of August.
Yes.
13th of September.
August. 13th of September.
No, August.
Why? You want more time?
No.
72, 73, 74.
74.
Yeah, 73.
76.
24.
Yeah.
State company.
State appeal.
Order of State Education Tribunal.
Industrial tribunal.
State Education Tribunal.
State education tribunal. What is the order? Brother, are you ready in the matter?
Not fully, well.
You take assistance of some youngsters, ask them to go through the file and points to you. All government, when we were government advocates, ASTs, etc., we used to distribute the files to extremely good law students. They will go through and they will prepare a note. That becomes easy. And they will get the certificate of experience also. Make use of them. Students will be there. Hire them. Just what is the matter? They also will be trained that way. That becomes easy for you. Otherwise, there will be, I understand difficulty of the government advocates. It's not that for them 1 or 2 cases. For you, there are at least 1 dozen cases.
That is a government.
First week of September?
Yes.
That's the request.
The 25.
Legal or adoption.
Brother,
I am challenging, my Lord, the judgment of the State Education Tribunal. Which
no, whether you ask your friend whether he is ready. Because so many matters are posted. I am just thinking.
I am giving a short note, my Lord.
Mohanty and senior members of the bar. I am just thinking. Is all FAO on one day?
That is on Friday.
Friday. And we can classify these matters that way.
Yes.
So that this expertise can be utilized for disposal of the case.
Yes.
Otherwise, one case comes FAO, another becomes regularization. Yet another comes about building demolition. Yes.
You will also classify, my lord. On which day you will also will take what matters and
That way.
Particularly so far the FOs are concerned, so they all relates to majority education matters. But a date will be fixed. By that time will be there.
Will be able to
and will be
prepare for
able to be.
Yes.
In fact, that is the.
Will tell the answer.
my lord.
Oh, put down these not many, but only.
On Thursday, my lord, it will be.
Thursday also, not Friday. It will be Thursday. It will be easier.
Today is Friday, man. Not leave it. Hereafter, let them solve these matters only on Friday.
Thursday, my lord.
Thursday. So that we can concentrate on those cases. Very, very old matters. These.
Old man.
This side or that side.
Yes.
People should know.
Yes.
Now here, I have challenged the judgment.
So next,
Here should be ready.
Next week, my lord, because he has, my lord, the appellant has already retired and is not getting the pension due to that, not getting that granted with effect from 1694, my lord. He is entitled to, my lord, but on the basis of wrong finding, the state education was denied him to.
Whether your case is covered by your friend also?
No,
Not case.
but it's completely separate case.
next.
Next Thursday. Next Thursday. Next Thursday may not be.
Next Thursday, my lord, is 7th.
22nd we will have school.
14th, my lord.
14th is Thursday, but some difficulty that day.
21st. You will also kindly take the death chart I am giving, my lord. You will also.
Which one?
I am giving the death chart, my lord. It will be easy for prepare.
That becomes easy for me. If this is not, because it's a matter of 22nd. 21st. Okay. Yes. Same way. On 21st we'll have.
Yes.
You come with preparation again and again. Don't cut. Sorry, figure in the code.
27.
FAO. Other. Put them on the same. 78, 79.
All four FOs. 9 is mine. All four are FOs.
All Thursday.
Some 25.
21. Any other date we have fixed in FAO? Some other date. Put all those dates to the subsidy. I said this on 21st. FAO 526 of 2020 for hearing.
Item 79, my lord. Item 79.
21st.
Along with my lord, FAO number 925.
Good. 79 to be called along with FA number so and so. I need a good commentary on Education Act. Book on commentary. We don't have that library.
Only that the books is there, my lord. This is there.
No commentary. Why you are not written commentary? By now you should have written at least one commentary, na? All right.
Thrash out and give one, my lord. We'll definitely thrash out and give one. Although I don't do this branch of law, but on item 80, my lord, it's a matter of 2019, I think.
2020.
Subject to pleasure of my lord, if it can be on a Wednesday or Thursday, any day, suitable to my lord, any time, I have no problem.
Thursday is all right to you?
Yes, sir. Deeply obliged. Any time, my lord, any day. I'm the respondent.
On 21, can we take 21st?
Yes, ma'am.
Yes, ma'am. This side. Yes, ma'am.
This side. 21st August.
Yes.
Inform your friends that we are putting it on Friday, on Thursday.
All FOs.
All FAO.
Also in the causality also, the FOs, this can also be circulated in normal way.
Very well. You can see.
In other courts also, this is being done.
No, for other courts I cannot make.
No. This can also be circulated like this, Thursday is meant for the
put the one line on the call list. The FAOs will be taken on Thursday.
My lord, I have one small request, my lord.
Yes, sir.
Event, my lord, on a Thursday. If I'm not available here, my lord,
And
may I
spread
be
over-
permitted to do it on virtual, my lord.
No problem. Are you coming from outside?
Delhi. I'm a lawyer from here, my lord.
Okay.
I have shifted when 9 to
Which date you want? You
Whatever
a
date,
special
sir.
case will take up your matter. Tell me, because all the way you are traveling from Delhi, you are most invited here to upgrade the bar.
My lord, we keep 1 week thereafter anytime.
On
Then this will be 4th.
4th of September. 4th of
Because of 27, 28 is a holiday.
holiday.
So then they skip one, this is the
One
4th.
Friday, if one Thursday is lost, it goes to other 2 Thursdays.
This can be spread over also.
That's all.
Otherwise,
Sir, can we take this matter on 4th of September?
No, I mean,
Or will it be too long?
No, I have no problem.
No
Because I am continuing in the.
Right.
I have no.
4th of September. 3 people. Thank you.